Good afternoon, everyone. We have a fairly long list today, but this first portion of our list will be to deal with scheduled non-pro-tunc hearings. That is, we are going to hear cases from individuals who have requested that they be permitted to submit late appeals. But before we do that, there's several preliminary things we need to put on the record. For everyone who's joining us virtually, please be advised that even though you are home or in some other remote location, this is a formal hearing. That means you need to approach it as if you were in the room with us. No reclining in your bed, in your easy chair. Please dress appropriately. Gentlemen should remove their hats. And if you are in a vehicle, we will not hear your case unless you are parked in a safe place. So those are the kind of things. This is a formal process. And finally, there is a court reporter who is recording everything that is said. If multiple individuals attempt to speak over one another, we can't make a clear record, and we need a clear record. Everyone who has a matter before us will be heard, and a resolution will be reached. Please pay close attention as we note any matters that are rendered moot or moot complied. So please pay attention. If your matter is moot or moot complied, that means it's resolved, and you may go home and go about your day. But if you want to remain and be part of this public hearing, you may do that as well. Okay, what I will do, we have a list of non-pro-tunc hearings matters. What I'll invite the law department to do, is there a general list that you need to bring before the board before we hear individual cases? I'm not sure who's the spokesperson. Okay, please come.
Good afternoon, board members. Sean Loeb for the city. There are a handful of preliminary matters I wanted to call the board's attention to before proceeding to the regular non-pro-tunc list.
Yeah.
The first matter is hearing number 7 on our list, appeal ending in 001386, appellant Jesse Smallwood, address 2741 West Allegheny Ave. This is a second listing, and my understanding is that the violation was issued to a corporate entity that requires an attorney.
Okay.
And I'm not aware if an attorney has been entered.
We normally hear uncontested matters. The appellant may wish to contest the.
Yeah, given that we're here, we're going to have to combine them in order to get through the non-pro-tunc list. So we'll hear both, any non-contested or contested.
I'm sorry
matter.
about that.
Is Mr. Smallwood present? Jesse Smallwood, are you present? Jesse Smallwood. Please confirm service, please.
Yes, sir. The appellants in this matter listed 1545 North 59th Street in their appeal. Notice of this hearing was sent to that same address on 7/22/25.
Okay, no response. What is your pleasure?
Hearing no response, the city requests city affirm for failure to appear.
Okay, that means the city would dismiss this matter for failure to appear. What time do we have?
12:11 p.m.
12:11 p.m. Regarding HA 2025-001386 2741 West Allegheny Avenue, Jesse Smallwood. This matter was dismissed for failure to appear.
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 Thank you. Oh, just for the record, Ms. Penn is joining us virtually, but her voice is loud and clear. Good afternoon. Okay. Anyway, please continue.
Yes, the next preliminary matter is case number 14 on our list, appeal ending in 002376, appellant Zakia Barnett, address 948 Belmont Ave. Also, case number 15 involving the same appellant and address. Both of those matters are moot.
Thank you.
Can we read the number for the second matter, please?
Yes, that case number 15 is appeal ending in 002377.
Thank you.
Next is case 19 on the list, appeal ending in 002433, appellant Charles Walsh, address 6109 Torresdale Ave. That matter is moot.
Thank you.
Next, case 21, appeal ending in 002444, address 409 Hermitage Street, appellant Ricardo Virella. That matter is moot.
Thank you.
Next, case number 22, appeal ending in 002453, appellant Mahari Gabrielazzi, address 7421 Lapwing Place. That matter is moot complied.
Thank you.
Next, excuse me, next is case number 23, appeal ending in 002460, appellant Raquel Cavalier, doing business as R&L Investment LLC, address 1945 East Allegheny Ave. And that matter requires an attorney since the violation was issued to a corporate entity.
Okay, is anyone here representing the interest in 1945 East Allegheny Avenue? Raquel Cavalier, doing business as R&L Investments, Inc. Are you present? R&L Investment LLC, rather. Anyone present?
Appellants in this matter, sir, are listed 1203 Herbert Street, Philadelphia, PA, in their appeal, and notice of this hearing was sent to that same address on 7/22/25.
Okay, hearing no response, what is your pleasure?
Hearing no response, the city requests city affirm for failure to appear.
Okay, what time do we have?
12:14 PM.
12:14 PM. Regarding HA 2025-002460, 1945 East Allegheny Avenue, Raquel Cavalier, Skivelier, doing business as R&L Investment LLC. This matter is dismissed for failure to appear.
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 Thank you very much.
Next is case number 25 on our list, appeal ending in 002466, appellant Legacy Furniture, Inc., address 2000 East Sterner Street. That appeal was withdrawn by the appellant.
Withdrawn? Oh,
Yes.
thank you.
Next are cases 26 through 31, and I'll read the appeal numbers and addresses individually. First one is appeal ending in 002486, appellant LA 1229 Chestnut Street, LP, concerning the address 1229 Chestnut Street. There is a joint continuous request in that matter, as well as the matters that follow. Case number 27, appeal ending in 002500, appellant 30 North 23rd Street, Associate Street LLC, address 30 North 23rd Street. Case number 28 with the same appellant, appeal ending in 002501. Case number 29 with the same appellant and address, appeal ending in 002502. Case number 30 with the same appellant and address, appeal ending in 002503. And case number 31 with a different appellant and address. Appellant is 220 South 16th Street Partners, and the address is 220 South 16th Street. So for all of those matters, 26 through 31, there are a joint continuance request.
Is this the first listing for all those matters? Do you know?
Yes, that is my understanding.
Okay, all righty. Based on the request, is the city, I assume the law department does not oppose the request? It's a joint request.
It's a joint request,
Okay.
yes.
So please, for the record, those matters are being continued.
Thank you. And finally, case number 37 on the list, appeal ending in 001517. Appellant Anwar Motan, doing business as Six Star Construction, for the address 2557 Coral Street. That matter is moot.
Moot, thank you.
And then going back to the top of the list, there's a matter requiring an interpreter. That's case number 6, appeal ending in 001383. I was speaking to the appellant in the hallway before coming up here, and I think we may be able to resolve that matter. So if you could just put it on hold so I can resume that conversation.
Okay, so we will come back, we'll pass it and come back to the, at the end of the list today.
That sounds
Will
good.
that give you enough time?
Yes, that would be great. Thank you.
Okay, all right, thank you. So we'll come back. All righty. Anyone?
Mr. Logue, since there is an interpreter on that case, could you notify us if you do get a resolution? We can-
Yes,
Okay.
Will
thank you.
do.
Do we have an interpreter on schedule for today?
Two interpreters were ordered today, one Spanish and one Malayalam.
What?
Malayalam, I believe. Malayalam.
Okay. The individual you're speaking with, which language would be?
So
So-
this is for case number 6, the Malayalam interpreter.
Okay.
I'm not familiar with that dialect personally, and I don't know if.
Oh, okay. But you can communicate clearly enough to
Yes.
resolve matters, you think?
Yes,
Okay.
the appellant needs the interpreter. Her son is also present, and I've been
Ah,
conversing with
okay.
him. So,
All right, we'll come back to it.
thank you.
Okay. Anyone else in the room that has a preliminary matter on the non-pro tunc list? Yes, please.
Good afternoon, Alana Larson for the city. Number 17, appeal number, or HA 2025-002407. That matter requires an attorney because the violation was issued to an LLC.
Okay, this is 950 West Benango, Sam Sharifli. Is anyone present representing the interests of 950 West Benango Street? Anyone present? And that's Sam Sharifli, Serefli. Anyone present? Anyone present?
Sir, appellants in this matter listed 950 West Venango Street, Philadelphia, in their appeal, and notice of this hearing was sent to that same address on 7/22/25.
Okay, what's your pleasure?
City affirmed for failure to appeal.
Okay, thank you. What time do we have?
12:19 PM.
12:19 PM. We will poll the board regarding HA 2025-002407, 950 West Venango Street, Sam Serefli, Serefli. This matter is dismissed for failure to appear.
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 Thank you. Anyone else in the room with a preliminary matter on the non-pro tunc list?
Excuse me, this is the court reporter. May I ask the attorney to repeat her name, please?
Yes.
I'm not sure I caught it.
Okay,
Alana Larson for the city.
Thank you.
I think he had it. Okay. You have some matters? Okay. Now, when I ask the preliminary matters, it's only for members of the Philadelphia, for the law department representatives, okay? The appellants, if you have an issue, check with one of the administrators in the back of the room, or Mr. Moto here. But if you have a question. Yes, sir.
Good afternoon again, board members. Sean Logue for the city. I was able to reach an agreement with the appellant for case number 6 on the
Okay.
list. And so I just wanted to read that into the record.
Yes, please.
And actually, I guess the appellant should come up as well.
Yes, sir. If you come up and you'll need to read the whole case in. Okay, the person who should be sitting in the green seat should be Josephina Anthony. So you sit in the green seat, yep. Okay, thank you. Okay,
So this is case number 6 on the list, appeal ending in 001383. Appellant Josephina Anthony, address 9938 Wingtip Road. And the city did reach an agreement to resolve this matter. The terms of that agreement are city affirm with a 180-day stay of enforcement.
Mr. Logue, just a
Yes.
mo- can we-
oh, we have the interpreter
Interpreter,
present.
I'm so
Yeah.
sorry.
is the Malayalam interpreter present?
Is he,
No one has identified themselves as the interpreter in the room, but they were ordered for today to be here now.
okay. Make sure that we're appropriately legal.
It wasn't.
Okay, let's proceed.
My recollection from the previous hearing was that there wasn't a high degree of confidence that an interpreter who speaks this specific dialect would be available, although they
Okay.
were ordered, obviously.
Okay. All right, so let's proceed and read in the agreement.
Okay, so the terms of the agreement are city affirm with a 180-day stay of enforcement.
Okay, thank you. Ma'am, did you understand the agreement and do you agree with it? You're speaking to the microphone. Give us your name, please. Okay, you may need to repeat, you pull the microphone closer to you. Okay, and just slowly give us your full name.
Josephina Anthony.
Okay, and do you agree with what the city's lawyer has said?
Yes.
Yes?
Yes.
Okay, thank you. All right, that resolves that matter. Unless someone else has an objection, we will proceed. Thank you so much. Have a good afternoon.
Thank you. And that concludes my preliminary matters.
Thank you. Okay, does anyone else have a preliminary matter? If not, we will call the non-pro-tunc list as is scheduled.
Good afternoon, members of the board. Kristen Patchell for the city.
Okay,
I'd like to direct your attention to number 32 on the list, which is HA 2025-002561, 820 West First Street. The appellant is a Michael Blackwell from Elmo Construction. Mr. Blackwell is present in the room. I would raise a standing issue for the
Okay.
members of the board.
is there Mr. Blackwell present? Oh, sir, please come forward. Okay, if you have a seat and give us your name, please.
Mike Blackwell.
Michael Blackwell?
Yes.
Okay, thank you. Raise your right hand. Do you swear or affirm the testimony you give be the truth so help you God?
I do.
Thank you. You can place your hand down. Okay, what is the issue?
So the NOV that was issued in this matter was issued, and of course indulgence while I pull this up. It was issued to a Mr. Luis Daniel Torres Melendez. Mr. Blackwell, from what I gather from speaking with him, is the expediter and appealed the notice of violation. I would just raise a standing objection as the individual issued the NOV did not appeal himself.
Is it issued to an individual or to a corporate entity?
It's issued to an individual.
Would you give us his full name again, please?
Yes, Mr. Lewis, Luis, Daniel, Daniel, Torres, Torres, Melendez, Meldez.
Okay, all righty. Mr. Blackwell, what is your relationship to this address and to this violation?
I'm the expediter.
You're the expediter?
Right.
Okay,
So I was commissioned in June to get the permit.
okay. In this instance, only the individual
Yes.
can appear before the board and or a legal representative.
Yes.
And so expediters, as great a job as you
Sure, I
guys
know.
do, don't fit the definition of a legal
Right.
representative.
Yes.
So,
Yeah, she articulated that.
okay.
Clearly, yes.
So he's gonna have to come. Is there any objection to continuing this matter?
No, that's
So
fine.
we will continue this matter and he'll have to come himself. You can't speak on behalf of the case.
Okay, I
Yeah,
got you. I'm
so if he
sorry.
wants to withdraw, he has to do it himself.
Okay, good,
So
good.
Chairman Woods, and I would just raise, and I'll defer to the board's discretion, but Mr. Miranda didn't file this appeal. Mr. Blackwell did.
Oh, so it's your appeal. So
On
which,
behalf
mean-
of-
on behalf,
yes,
yeah, but
yes.
that means that,
If it is his appeal, he may withdraw it.
okay.
However, do you want to speak about the,
Well, no, let's just deal with him withdrawing his appeal. You want to withdraw your appeal?
Yeah, we'll withdraw and just go ahead. and
Okay,
follow
let the record
procedure.
reflect that the appellant, Mr. Michael Blackwell has withdrawn the appeal.
Yes.
Yes,
Okay, you will inform your client. He'll have to
will.
decide what he wants to do.
that's correct.
Okay, all right, thank you, sir. Have a good day.
Thank you.
Thank you.
Okay. Okay, anyone else? If not, we will call the list in regular order.
Bring your attention, sir, to item number 1 on today's list. Let's hearing appeal ending 3183, 110 South 54th Street, Michael Lawrence.
Yes, please come forward, sir.
Good afternoon, members of the board. Jeffrey Cohen on behalf of the city of Philadelphia.
Okay, thank you. Sir, if you give us your name, please.
Michael Lawrence.
Michael Lawrence, would you raise your right hand to be sworn? Do you swear or affirm the testimony you give today be the truth to help you God?
Yes.
Okay, thank you. You can place your hand down. Mr. Lawrence, you should understand that purpose of this hearing is to determine whether to permit you to submit a late application, appeal application. And if we agree with your request, that means we will schedule a hearing. If we do not agree, your appeal will be dismissed. Okay? And so the purpose of here is not to hear the underlying violation, is to determine whether or not you should be permitted to submit a late application for a hearing. Okay?
I hear you.
Now, I will give you some dates, and then we need to understand what's happening here. According to our records, there was a violation entered on March 20th, 2024. You submitted an appeal on August 1st, 2024. And according to the violation, the language of the violation, you get 30 days to submit an appeal. You submitted your appeal, it should have been by April 20th. You submitted it in August.
Okay.
And so you need to explain to us why we should allow you an exception to the rule.
I was in the hospital.
Okay, give us some information.
I had heart surgery.
Okay, when did that happen?
That was in 2024.
What dates?
I don't have the dates right now, but it was at Penn University, so.
Okay, yeah, I
was
need to
there-
have
been
a
there for
sense of,
3 months.
were you in the hospital before the violation was written? After the violation was written?
Well, when I found out about the violation, and I addressed it when I found out about it. And then, but then I told him, I says, I was sick. And that's, I think the violation came about because I had some friends.
Yeah, the why it came about isn't important right now.
Okay.
We're just trying to get a sense of how your illness affected your response.
Yeah. well,
Were
I
you
was-
sick at the time that, during that 30-day period?
I'm sure, yes.
You sure? You certain? Okay, you don't have any idea what months you were in the hospital?
Not exactly, no, but
Well, give me an approximation.
It was all last year, 2024. And
Between January and December or what?
Right, around January.
Okay. All right, any response from the city?
Yes, but before I speak, I would like to at least mention that Mr. Lawrence and I did have an opportunity to speak before this hearing. I did hand Mr. Lawrence a copy of the Court of Common Pleas final order in the Court of Common Pleas case that is mentioned in the city's exhibits packet. And just briefly, without, the exhibits packet has been provided previously to the board and to Mr. Lawrence. I don't want to necessarily rehash it here. But the notice of violation that is the first exhibit in the packet is from October 7th of 2022, which pretty definitively rules out any interference from a hospitalization in 2024. The city also has 3 different methods by which that notice was served. It was because it was an imminently dangerous violation notice, it was actually sent by first-class mail, also dated October 7th of 2022. And it was also received and signed for by Mr. Lawrence by certified mail on October 17th of 2022. Those are exhibits C2 and C3 in the packet.
Okay.
And then when the Court of Common Pleas case was filed, it was served personally to Mr. Lawrence on August 4th of 2023 per an affidavit that was filed with the Court of Common Pleas. That affidavit is exhibit C8 in the packet.
Okay, and is the common pleas case still pending, or has there been a?
No, there was a final order in January of 2024, which is exhibit C9 in the packet.
Okay, final order in January 2024? Okay, so this is an ongoing matter.
Well, the violations are ongoing, but the Court of Common Pleas has ruled there was no appeal from that final order. So in
City has
addition to this being an untimely late appeal request, there's also not much relief that the board can grant, even if it were to grant late hearing, because the Court of Common Pleas has already ruled. The Court of Common Pleas has essentially
believe
tied the board's hands.
We should resolve the jurisdictional question first before we talk about issue preclusion or
Make sure you put your name on the record.
This is Matthew Webster, Board Counsel. I just wanted to mention we should resolve the jurisdictional question first. Now,
Is that something we can do before the non-pro-tunc matter is completed? Because the jurisdictional matter
no,
prevails.
the nunc-pro-tunc gives us jurisdiction.
Okay.
A late appeal, we have no jurisdiction without nunc-pro-tunc relief.
Okay,
That's what I'm saying is we need to hear the timeliness arguments
Okay.
first.
Sir, Mr. Lawrence, you have an attorney representing you in all this stuff, right?
No, I don't.
You went to common pleas court on your own?
Right here, I came.
No, this is the appeal board. Did you go to common pleas court on your own? You weren't represented by an attorney?
No, no.
Okay.
I was actually the attorney who handled the common pleas matter on behalf of the city. This is actually the first that I'm meeting Mr. Lawrence in person.
Oh, so there was no one present?
That's correct. There was a default judgment
Default,
entered
okay.
and then a final order after a hearing at which Mr. Lawrence did not appear.
Okay. All right, thank you. All right, just for a moment, we're going to have to take an executive session. Just for a moment, please. Okay, we prepared to go back on the record? Okay, thank you very much. We've heard the arguments both by Mr. Lawrence and in response from the city. We're prepared to render decision in this matter. With regard to HA 2024-003183, 110 South 54th Street, Michael Lawrence, request for late appeal or non-pro-tunc relief is denied.
Request denied.
Request denied.
Request denied.
Request denied.
Thank you. Mr. Lawrence, we denied your request to submit a late appeal. That's what that vote means, okay?
Right, so
Well, you need to consult an attorney to decide what your next moves would be, okay?
all right.
All right, thank you. What's that next matter?
Calling your attention, sir, to item 3 on today's list. That's hearing appeal ending 1254, 2308 St. Alban Street. Sean O'Rourke, Melissa Howell, and Susan Coffin. Michael McElhenney Esquire is representing.
Okay, is Mr. McElhenney present?
On Zoom, Mr. Chairman.
Okay, good afternoon, sir.
Good afternoon.
Ms. Rhoda?
Thank you. May it please the board, Leonard F. Reuter, R-E-U-T-E-R, Senior Attorney, City of Philadelphia.
Okay, thank you very much. Mr. McElhenney, you're very familiar with this process. According to our records, the violation was written January 30th, 2025. The appeal was submitted April 7th, 2025. Is there a defense for the tardiness?
Yes, members of the board. And my client is, at least Sean O'Rourke is in the courtroom or in the hearing room if necessary. But in a nutshell, this is an appeal of a building permit, not a violation. My clients are the next door property owners at 2304 and 2306 St. Albans. The property owner at 2308 St. Albans obtained a building permit after a historical commission review that approved a rear addition to this historic property. And the request for the appeal, the reason that it was late filed, we believe it's timely filed because the property itself, there's no notice of a historic commission staff level decision to any neighbors. It's a private decision between the property owner and the applicant that we believe should have went to the full commission. That being said, a building permit was issued to the owner of the property next door on January 30th, 2025. We filed an initial appeal of the zoning permit to the zoning board that's tangentially related to this case. We did file a notice of appeal of the building permit once we got knowledge of the permit. The permit was never posted, though, publicly at the property. And a part of my nunc-pro-tunc application, we attached photos of the property showing the permit wasn't publicly posted. So neighbors would have no notice as required by the building permit itself that requires you to post the property. There's the building code. So we would submit that there's no actual notice of the neighbors on the this historic St. Albans Street block of the building permit, so that we would request that the nunc-pro-tunc be granted so we can have a full hearing as to the propriety of the historic commission staff approving an addition to the historic property.
Okay, any response from the city?
Yes, specifically first of all, as far as the posting of the permit goes, the city doesn't have specific information of if or when the permit was posted at the property itself. We don't go out to verify that immediately or anything like that. So that's first question the city would have actually for the board or for the appellant is whether the property owner was notified of this appeal, because the property owner is the one that's in the position to demonstrate whether or not a permit was properly posted in a timely manner. So, but with respect to the underlying argument that they've never received notice of the Historical Commission's action, first of all, this permit, as Mr. McElhaney already indicated, was approved at staff level. So, but even if it had been approved by the full commission after a meeting, the case law, the Commonwealth Court has already addressed protestant or third-party appeals from permits that are issued subject to approval of the commission. And the court has said that the commission is not is under no obligation to notify third parties, neighbors, or anybody like that of their decisions. The decision led the parties to the commission matter is basically the applicant. The applicant submits the permit application, seeks approval. The commission makes a decision. They either grant or deny approval. That decision letter goes to the applicant. There may be posting of it online or something like that, but the court, and that's Berger and Montague, 898 A second 1. So that's Berger and Montague or Montague PC versus Philadelphia Historical Commission. And that involved Berger and Montague, the law firm, seeking to intervene seeking to get a late appeal from a historical commission decision in that case. And then that also referenced the Oliver case, Oliver versus this Board of L&I Review, 761 A second 214 from 2000, again, where the court discussed the basis for third-party appeals and the timeliness of third-party appeals. And the timeliness goes to, they have to take that appeal within 30 days of when they knew or should have known of the issuance of the permit. So again, there's no obligation, and there was never going to be a day when the Historical Commission was ever, even if they had a regular meeting, that the Historical Commission would provide any notice to neighbors of their approval. There are certain permit applications that do get posted. Demolition permit applications, for instance, will get posted, that kind of thing. But alteration permits, there's no posting requirement for that if they're seeking commission approval, and the commission decision wouldn't go to neighbors. In this case, again, it was a staff level approval. So staff just basically stamps off on the application, and it goes to through, in this case, through the Eclipse system, and then L&I finishes their review, and they either issue the permit as they did here, or they don't. So in this case, the permit was issued. As far as the knowledge of what was happening here, Mr. McElhaney himself again referenced they had a separate appeal that was taken to the zoning board from the zoning permit, which was issued just a few days prior, a couple weeks, I think, prior to the issuance of the building permit. That permit, that zoning permit was timely appealed to the zoning board, and it's the city's contention that, well, the zoning permit had been issued. There were a number of other things going on at the property at the time, and it's the city's position that it strains credibility to suggest that the appellants here were unaware of there being a building permit having been issued. That said, with respect to the only really outstanding issue that the city can't address, which is whether the permit itself was properly posted in time, we don't have information that goes to that one way or the other. We don't.
Okay. I guess I would also have a question for Mr. McElhaney. Your appeal is of the zoning decision, or is it of the issuance of the building permit?
The building permit.
Okay. You said that you have some photographs regarding what's posted or not posted, and do you have those available?
I do. If I could share my screen, I could post them for you.
Yeah, if you could do that, please. I assume they're date stamped.
Yes.
And is the individual who took the photos present?
Mr. Sean O'Rourke is sitting in the room.
Yes, if he come forward, please. And I'll swear him in, then we'll have, sir, give us your name.
Sean O'Rourke.
Okay, you're right. Please raise your right hand. Do you swear or affirm the testimony you give today we do truthfully help you God?
Yes.
Okay, Mr. McElhaney, just a little, some foundation, please, as to why he's here?
Yes, Mr. O'Rourke, are you one of the appellants in this case?
Correct.
And is your address 2306 St. Albans?
Correct.
And where is that in relation to the subject property, 2308?
We share party wall with 2308.
And did you authorize my firm to file an appeal of the building permit issued to 2308?
Yes.
And as part of the appeal to the board before you that we're at today, did you submit and take photographs of the property at 2308 in terms of the posting of permits at the property?
These photographs were either taken by my wife or myself, and we were in the presence of each other.
And the photograph I have on the screen, I have it marked as part of Exhibit 3. What is
Can you rotate it a bit? There you go. Thank you.
I'll rotate it back when they go different directions. Is it fair to say the photograph on the screen is Exhibit 3 is a photograph of 2308 St. Albans?
Yes.
And what's the date that photograph was taken?
I don't remember, but it says on it March 25th, 2025, 7:43 in the morning.
And in the window, are there pieces of paper taped onto the window?
Yes.
And were they permits?
I remember them as being demolition permits.
So I'm going to turn to the second photograph of Exhibit 3. Can you see what that permit actually states?
It's labeled as a general permit minor.
And looking at the next photograph?
Similarly, notice of general permit minor.
And looking at the type of work, does it say that it's for easy interior renovation?
Yes.
Oh, before you move on, what are the dates on those? I can barely read the dates.
Let me zoom in a little more. Looking at the top right corner, can you see the date this minor permit was issued?
9/25/2024.
And what was the scope of cost of work estimated?
$3,000.
And as you stated, you believed it was for interior demolition?
Correct.
And is that what the approved scope of work says at the bottom?
Yes, for the interior demolition or non-load bearing partition walls, ceilings.
Looking at the third photograph, okay, would you agree with me that this is the rear of the subject property?
This is the rear of the subject property that is on Fulton Street.
And what's the date that photograph was taken?
March 24th, 2025, 6:14 PM.
Were there any permits posted at the rear street to the property?
No, nothing on Fulton Street.
So going back to the first page of the photograph, were there any, other than the minor permit that you just testified to, was there any residential building permit issued from January of 2025 that was posted in the window as of the end of March 2025?
No, they were only posted after our initial hearing.
And then turning to Exhibit 4, is that another photograph of the front of 2308 St. Albans?
Correct.
And what's the date that photograph was taken?
March 28th, 2025, 9:42 AM.
And are those same 3 permits that you just testified to still in the window?
Yes.
Is the new residential building permit in the window?
No.
And turning to the second photograph of Exhibit 4. Again, is this a photograph of the rear of 2308?
Yes, on Fulton Street. It's dated March 28th, 2025, 9:41 a.m.
And were there any permits on that side of the property?
None at all.
And the next, page 3 of Exhibit 4, again, is that a photograph of the permit that was in the front window?
Yes,
And that's the minor permit, correct?
correct.
And turning to the next photograph of Exhibit 4. What is that? Is this a photograph of a piece of paper that was in the window?
Yes.
And what was this paper? What did this paper actually state?
I think it states easy permit standards for interior demolition.
And that gives the scope of work that you're allowed to do under that minor permit?
Correct.
And the next photograph, is that, again, just the second page of the minor permit that was issued?
Correct.
Next, I'll direct your attention to Exhibit 5, which, again, is this photographs of the front of the property?
Yes.
And what's the date that photograph was taken?
April 9th, 2025, 11:44 in the morning.
And you agree with me that was after your appeal to the board was filed?
Yes.
I think your members of the board, all these photos are post dating the filing of the appeal.
Do you
showing
have any
as a-
do you have any photographs of the general construction permit to construct the new addition?
I don't know if we have a close up. I don't have a clear photo of what was posted at a later date.
Okay,
It's not visible.
okay. All right, thank you. All right, Mr. Broad, any additional response before we decide?
Just a couple of questions, sir. You have been reviewing the photos that have been shown by your counsel, Mr. McElhaney, all of which were taken from towards the end of March, say March 24th through April of 2025. Would you agree that all of those photos you were just referring to were taken around that time period?
Yes.
Okay. But you were aware that a zoning permit had been issued in early January. Is that correct?
We had heard rumors of it.
But you filed an appeal by the end of January, didn't you?
Correct.
Okay, so you knew about that permit having been issued. And were you also aware of the project plans that the owner had for the property?
In discussions with the owner kept changing the scope of work and the project plans, and we could not trust that he was ever telling us the truth.
Okay, and from the time that you knew of the zoning permit having been issued until this appeal was filed by your counsel, did you make any attempt to check the L&I records, the Atlas online, or anything like that to see what permits might have been issued for the property?
Eventually, we did, yes.
But not until April.
I don't remember exactly.
Could it have been in March or February?
It could have been, yes.
Okay, so you don't know, you can't tell this board today when you actually learned of the permit for the addition.
Through the city website, no, I can't tell you that.
Okay. I don't have any further questions.
Members of the board, may I just ask one follow-up?
Yes, please.
Mr. O'Rourke, the city attorney referenced that you and your wife, Melissa Howell, filed an appeal of the zoning permit, correct?
Yes.
Susan Coffin, the current appellant with you here, she was not a part of that appeal, was she, to the zoning board?
I don't believe so originally.
No further question.
Okay, I guess I do want to understand something. The resident of 2308, the subject property, is that individual owner occupant, or is this an investor renovation?
That is a investor The company's name is Bengi Inc., Bengi. His attorney is Alan Nachumson.
Okay. Okay, are they present today for this discussion? Are you aware?
The
Miss
city's not aware.
Amanda
And-
Doherty is on the Zoom. She's with that firm. I don't know if she's here for that matter or another.
Yeah, again, that was the initial question we asked, is whether or not the property owner had been notified of this appeal.
Okay.
Since it's a third-party appeal, they would normally
Yes.
need to be notified.
Mr. McElhaney, can you respond to that?
I believe the answer is yes. I can go back and I would have to double check. Mr. Nachumson did reference in his brief to the zoning board that he was aware of our pending appeal to this board of the building permit. And
Okay.
that's exhibit 19 of my packet.
Okay, thank you. All right, just for a moment, any additional questions by the panel or the board itself? Ms. Penn, any questions? Okay, if not, we're going to take a very short executive session.
Before we do that, I do have a question. Mr. Reuter, does Mr. O'Rourke and the other lady file the appeal? Does anyone have a duty to notify the actual the person against the appeals to L&I, but it involves a permit for the property next door? Does
So-
the city have any duty to notify the next door party?
There's no, well, I'm not aware that the city itself, as the appellee, would have any obligation to do that. I think it's up to the individual board. The zoning board, if there's an appeal against L&I from the issuance of a zoning permit, the zoning board itself will notify the permit holder that an appeal has been filed. It's very rare for these types of appeals to come before this board. So I don't know if there's any established protocol for that. I do believe there's an argument that could be made. Again, it's not the city's argument, but it's an argument that could be made and is potentially may be made if there's a subsequent decision, if there's a decision and there's an appeal, which is that it would be it's arguably a due process violation to proceed and to essentially revoke the issuance of a permit to the permit holder if the permit holder never had noticed that this appeal was happening. So I think that's something to keep in mind. But I don't know whether they were notified of this or not.
Well, and Mr. McElhaney is representing that the neighbor or their attorney were aware or are aware of the hearing that's taking place today? Mr. McElhaney, is that a yes or no answer?
I did not send a copy of the hearing notice to Mr. Nachumson's office.
I can say, and again, just based on my recollection from the zoning permit appeal case, which Mr. McElhaney and I were also involved in, but where Mr. Nachumson did appear, I do believe Mr. Nachumson was aware that there had been that there was an appeal or had been an appeal from the building permit, but I don't know if he received any notification or notice of the dates of that.
I have one further question, sort of a little off to the side, but because an appeal was filed of the building permit, what is the status of actual construction at the property? Is it stayed?
That's a great question. Actually, the construction is ongoing. We've had discussions about resolving the dispute, and we have I'll say it this way. The owner appears not to be doing the addition at this point. So it all may end up being moot at the end, but we could not have an agreement that they would amend the plans to not have the rear addition that we think was improperly approved. But right now, construction is almost completed. The property is listed or having people showing it, and the addition's not actually being built as of now. But there is a permit that says they can.
So, all right, so there's construction work that's taking place. However, the building permit that is the subject of this appeal has not been implemented to the extent it involves an addition. Is that correct, Mr.?
I would say
McElhaney?
that's accurate.
Thank you.
And again, I can follow up. Again, this case had previously been listed back, I forget when it was.
July 1st.
July 1st, that was the strike. And it was continued, I think initially to August 14th, and then there was an agreement to continue that because there were negotiations going on. So again, it's my understanding that the property owner never got formal notice of the board appeal or the dates, like they were never made a party officially through, whatever you do to make them a party at the board level. But the city was aware of the fact that they were in negotiations to resolve this, indicates that they knew something was going on. But again, whether they were ever formally notified of today's date, for instance, I have
And
no
and what's
idea.
the status of the zoning appeal?
That was dismissed, and I don't think there was any appeal from that, so,
Dismiss lack of jurisdiction
correct.
because the zoning board only reviews zoning permits involving historical commission in two very limited circumstances. But they just don't apply here.
Okay,
Mr. Chairman, may I ask a very quick question?
yes, please.
So, Mr. McElhaney, I haven't heard from you or your client any explanation as to why there's an objection to the construction? Or because what I'm hearing is just an objection to the process for the applicant, for their not being notified that a construction permit had been issued. But what is actually the objection to the work that's being done? I mean, if they've got approval from the Historic Commission, it's not impacting their property directly. What's the issue?
Well, the issue is, may I share my screen quickly?
Well, I just want to
can show you the
caution-
rendering.
Yeah,
They
yeah.
can,
I just want to caution everybody, this is a non-pro tunc hearing, not the underlying violation issue.
Right, right.
Yes,
But
it-
we spent a lot of time talking about the procedure, but not,
Yeah,
but
I
no
just-
reason as to why the appeal was filed, other than they didn't like it. But I mean, to me, that's not sufficient.
I just want to ask Mr. McElhenney if your response
Just
could be
briefly.
briefly as possible, and we don't need an
Yes.
extensive
Right.
conversation.
the argument is that the staff level didn't have authority to grant this over the counter. It should have went to the full commission where we have a public hearing that we would have participated in. The addition impacts the historic structure and historic block of the St. Albans Street. That should have gone to the commission for public input. My
Sure.
client's property next door, the addition, it's a shared side alley, rear alley. That the addition then blocks light and air, and it's unsightly and not in keeping with the characteristics of this historic block.
Okay.
All
Thank
right,
you.
Thank you very much. Anything else, Ms. Penn?
No, nothing else. That's all
Okay.
that's all I was thinking it might be, but.
Thank you. We're going to take a very, very quick truncated discussion before we render our decision. Thank you. Okay, thank you very much. Before we vote, I do have one final question here. Not sure who to direct this to. And Mr. McElhenney, I'll start with you. Is it an expectation that if a permit holder's permit is being challenged at a non-proton hearing or at a subsequent hearing, if relief is granted, should be notified so that individual or company can participate in the non-proton hearing and offer countervailing facts or information? You're muted, sir.
Yeah, I viewed it as an appeal against LNI for the issuance of the permit. It affects their permit. I don't have at my fingertips whether if I sent a formal letter to serve the opposing counsel or the owner. I do know that they were on emails and whatnot about the appeal being filed and pending before this board.
Okay,
but-
and because there's an assumption from some that they may say, look, we did post a permit, we posted it on the other window higher up or whatever. I don't know what the argument would be, but there is an argument potentially. Okay, Mr.
Yeah.
Rauter, before we vote.
Again, I think the property owner in this type of a case is obligated to know that an appeal has been filed, whether there's necessarily some formal process that requires them to be a quote unquote party, that I don't have an opinion on. But again, I think with the zoning board, we have appeals against LNI probably twice a month on average, and they have an established protocol. And I think the protocol is actually, they direct the appellant to notify the third party, or sometimes they just send the notice themselves. But the permit holder is always notified one way or the other. Again, because these types of appeals are very, very rare here. I mean, you're probably going to hear maybe 3 of these a year, if that. There's no established protocol, so I'm not suggesting that anybody did anything wrong. I just think that obviously if Alan Malcolm's in and my client has their permit revoked after a hearing that I was never notified about, that's obviously a problem, so.
Okay, all right. No, sir, you're the witness called by Mr. McElhenney, so you have to sort of connect with him before you, Mr. McElhenney, your witness, I think wants to contribute something, so how you want to handle that?
I believe if he's there, if he has something to advise the board, I have no objection.
Okay,
Board, I would just want to tell you that we see the developer working on this.
Excuse me, this is the court reporter. I cannot hear the gentleman.
yes, sir, you have to be very
Okay.
close to that microphone.
I apologize. We see the developer as he runs his construction crew on a weekly, bi-weekly basis. And in conversations about negotiating a settlement with this, I believe that the owner, the developer of this property knows that this appeal was going on and that it was dated. I can't say that there's any proper notification sent to his lawyer, but he knows this is going on.
Okay. Thank you. We will now poll the board regarding HA 2025-001254-2308 St. Albans Street, Sean O'Rourke, Melissa Howell, and Susan Coffin. Request for non-pro-tunc relief granted.
Request granted.
Relief denied.
Relief denied.
Request granted.
Okay, the majority vote is request granted. So, sir, a regular appeal hearing will be scheduled for this project. Have a good afternoon.
Thank you for your time.
Thank you.
Thank you, Board.
What's next? Yeah.
As a bookkeeping matter, sir, we received notice here at the board that the appellant number 24, hearing appeal ending 2464 5823 Ashland Avenue, has requested a continuance in today's matter, and the city is here to address their response.
Okay,
We don't have any objection
Who's
to that.
we?
Oh, sorry, I'm sorry. Amy Skiles on behalf of the city. I don't have an objection to the request.
okay, so HA 2025-002464-5823 Ashland Avenue will be continued.
Thank you.
Thank you.
Our next matter today is going to be item 18. That's hearing appeal ending 2422-176 East Tolpahocken Street, Franklin Johnson. Forgive me, sir.
This is regarding something, a different matter?
Yes.
Okay,
Good afternoon, board members. Sean Logue for the city. I had a chance to speak to the appellant for case number 9 on the list. Appellant Zheng Ji, appeal ending in 002149, address 3427 Sheffield Ave. We discussed a possible settlement agreement, but she would like to consult with counsel. And so I've agreed to a continuance, or let her know that I would not oppose a continuance.
okay, so we will note for the record that HA 2025-002149-3427 Sheffield Avenue is continued.
And I believe Ms. G is still present via Zoom.
Okay. All right, well, we'll continue. Okay.
Thank you.
All righty. Before we continue, I have Mr. Sam Logue, Sean Logue rather, has his hand raised. That was you? Okay. All right, thank you. All righty, call the next matter. 18?
18 on today's list, sir. Hearing appeal ending 2422-176 East Tolpahocken Street, Franklin Johnson.
Okay, who's representing the city?
Afternoon, members of the board, Jeffrey Cohen for the city.
Okay, and Mr. Franklin Johnson, that's your name,
Good
sir?
afternoon, Franklin Johnson.
Okay, sir, would you raise your right hand to be sworn? Do you swear or affirm the testimony you give today be the truth to help you God?
Yes, sir.
Okay, thank you. Mr. Johnson, as you've heard, I assume you've been listening as we've gone through these non-proton cases, is that this is a preliminary hearing to determine if in fact we will schedule a regular hearing appeal case for you. Based on the dates that we have, your violation was noted on November 16th, 2024. We have an appeal date of June 20th, 2025. Violation notices, appellants have 30 days to appeal violation notice. And this is far beyond that matter, it's close to 7-8 months. So what is your reasoning for submitting a late appeal? I mean, a late appeal.
Well, the contractor was actually supposed to submit the appeal, but,
Okay, wait a minute. Are you the owner of the property?
yeah, I'm power of attorney.
Power of attorney for who?
The city would object on that point. The owner of the property is Germantown Holdings LLC,
Oh,
which must be represented by an actual attorney before this board. I don't believe Mr. Johnson could act as an attorney as merely a power of attorney.
okay. So we have a standing issue even before we can get to the point of a non-pro tunc matter. What is your relationship to the property?
I'm purchasing the property.
Have you gone to closing yet?
No,
You have not. Okay. So is there any reason why someone from the LLC is not present?
I normally deal with most of the matters.
Okay. Is there any reason why the LLC is not represented here by legal counsel?
I'm not sure. You know, I
Okay.
haven't-
All right.
Do you have an agreement of sale? You said you're purchasing it individually, or is it?
Yes,
You're purchasing it from Germantown Holdings?
correct.
Do you have an agreement of sale written with them?
Yes, I do.
Do you have a copy of it
I
here?
don't have it with me, no.
All righty. And I guess the final question I would ask, why are you appealing this and not them?
Cause I was the one that had the gate put up.
You, pardon me?
I am the one that had the gate put up.
Oh, there's a gate here. This is okay. All right. Building permit issue. Okay. We can't hear this. You don't have standing. You don't have standing to submit an appeal based on the current ownership records. And if Germantown Holdings were to submit an appeal, they must be represented by legal counsel because it's a corporation, unless I have different opinion from somewhere.
Can we have a slight executive session?
Okay, we need advice from our legal counsel. Sir, give us quick advice. Back on the record. We're going to do something that we're a little different than we normally do. We're going to bifurcate our decision on this matter. We have a concern about standing, sir, and you don't have any evidence that you in fact do have an agreement of sale. You don't have it with you.
Well, I do have something.
Well, but all we have to go on is your word, unless you have something in your paperwork.
I have something on record with the city that I'm power of attorney.
Power of attorney is not the issue. It's whether or not you have an existing agreement of sale, which gives you certain
Sir,
equitable standing.
you can't be power of attorney for an LLC, for a corporation.
No, I understand that part, sir, but just power of attorney to be able to take care of different matters with the municipal building.
Well, if I can ask a preliminary question.
Yes, please.
If there's a ruling on untimeliness of the petition that was filed by Mr. Johnson, then does the board need to address the issue of standing of who he is, how he's
We
related?
could do it in reverse unless we have different advice from counsel.
I believe Mr. Cohen is correct. There is no current appeal before the board. We don't have jurisdiction over the appeal. We must find jurisdiction by nunc-pro-tunc relief
Okay.
first before addressing the issue of standing.
Okay, all right, so we'll do it the other way then. Okay. Sir, what is your defense for being late? Assuming we determine that you have standing.
The contractor, I was under the impression that the contractor was going to file the appeal, the contractor that put the gate up, that he'd been giving me the runaround. So since then, I obtained an architect that's in a process of drawing the archive up for the zoning, and I'm in a payment plan with him, so I'm paying him off. That's why he didn't submit any.
Okay. All right. Just one moment.
Just a second. Stop Hawkins Street.
Okay, sir. So we're looking at a matter that's 7 months late. Okay. All righty. So we're prepared to vote, determine whether or not to grant you a late appeal, your late appeal request. HA 2025-002422, 176 East Tupper Hawkins Street, Franklin Johnson, request for non-pro tunc relief denied.
Request denied.
Request denied.
Request denied.
Request denied.
Thank you. Mr. Johnson, your request to submit a late appeal has been denied, so the appeal will be dismissed. Okay? All right, thank you very much, sir.
Moving forward, could you guys recommend what the best thing for me to do in this manner?
Hire a lawyer.
Hire a lawyer.
Yep,
Yep.
that's the best thing. To help, a real estate lawyer who can help you navigate this whole thing, okay?
All right, thank you very
You'll
much.
get a notice of the decision that gives you 30 days to file an appeal of our decision. And then you can seek whatever advice you want as to
Okay.
how to go about dealing with that.
All right, thank you.
Okay,
It
thank you.
may also help to speak with L&I. In the upper right-hand corner of the notice should be contact information for the L&I district.
All right,
I've been speaking with Lazarus.
Oh, okay, then you're already speaking with her. Thank you.
thank you very much. Okay, what's that next matter?
Sir, just if I can bring your attention to item 33, that was hearing appeal ending 2638 for 3430 North Bodine Street. There was a request for a Spanish interpreter, but I have not yet seen the interpreter join us. If I can inquire to the room.
Okay, let's do this. Let's hold this to the very end.
Yes, sir.
Hopefully the interpreter will show up before that.
Yes, sir.
Okay, thank you. Let's move on.
That would bring us back to the top of the list, sir. It's item number 2 on today's list. That's hearing appeal ending 1167 4106 Holmesburg Avenue. George J. Shapley and Kevin Edeline.
Okay, we have Joseph Vaccaro is listed as counsel for the appellants. Mr. Vaccaro, are you present? Okay. So this, ma'am,
Good afternoon, Amy Skiles on behalf of the City of Philadelphia.
good afternoon. Anyone present representing the interests of 4106 Holmesburg Avenue? George J. Shapley and Kevin Edeline. Anyone present? Anyone present? Okay, we're going to confirm service and then we will make a decision.
Sir, the appellants in this matter listed 4106 Holmesburg Avenue in their appeal, and notice of this hearing was sent to that same address on 7/22/25.
Okay, there's been no response. What's your pleasure?
And just to provide some further information, this was originally listed July 1st. Mr. Vaccaro did appear at that court date and request a continuance. So he is aware of this appeal. So we would ask that this be dismissed for a lack of appearance.
Thank you. What time do we have?
1:29 PM.
1:29 PM. Thank you. We will pull the board regarding HA 2025-001167, 4106 Holmesburg Avenue, George J. Shapley and Kevin Edeline. This matter is dismissed for failure to appear.
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 Thank you very much.
Dismissed for failure to appear.
Thank you. Okay. What do we have next?
Calling your attention to item 5 on today's list. That's hearing appeal ending 1341 105 Chestnut Street. Jose Barreto, appellant.
Who's representing the city?
That's Mr. Reuter.
Okay. Okay. Is Mr. Jose Barretta present or anyone representing Mr. Jose Barretta? Barreto, Barretta. Barreto.
We'll put that one aside,
No
sir.
one has responded. We will move on and come to another matter. We'll come back to this one.
Calling your attention to item 8 on today's list, hearing appeal ending 1471 1640 Powell Road, Elizabeth McNair.
Who's representing the city?
Alana Larson for the city.
Mr. Larson, good afternoon. Anyone present representing the interests of Elizabeth McNair? Elizabeth McNair, are you present? Okay, no one is responding. Let's confirm service.
Appellants in this matter, sir, are listed 1640 Powell Road in their appeal, and notice of this hearing was sent to that same address on 7/22/25.
Okay, what is your pleasure? With no one's responding.
Hearing no response, the city requests to dismiss the case for failure to appear.
Okay, what time do we have?
1:31 PM.
1:31 PM. We will poll the board regarding HA 2025-001471, 1640 Powell Road, Elizabeth McNair. This matter is dismissed for failure to appear.
Dismiss for failure to appear.
Dismissed for failure to appear.
Dismissed for failure to appear.
Dismissed for failure to appear.
Thank you very much.
Thank you. That concludes
You're
my
welcome.
matters.
Let's go back then to number 5. Mr. Rauter, I think, has entered the room.
Recalling item number 5 on today's list, hearing appeal ending 1341 105 Chestnut Street, Jose Barreto.
Mr. Barreto did not respond to the earlier call, so we need to confirm service on the record before we proceed.
Appellants in this matter, sir, are listed 105 Chestnut Street in their appeal, and notice of this hearing was sent to that same address on 7/22/25.
Okay, thank you very much. There's no response. Mr. Rauter, what is your pleasure?
First, my apologies for being out of the room for a moment, and the city would ask that this matter be dismissed for failing to appear.
What time do we have?
1:33 PM.
Okay, thank you very much. We will poll the board regarding HA 2025-001341, 105 Chestnut Street, Jose Barreto. This matter is dismissed for failure to appear.
Dismiss for failure to appear.
Dismissed for failure to appear.
Dismissed for failure to appear.
Dismissed for failure to appear.
Thank you.
Thank you.
Okay,
Bring your attention, sir, to item 10 on today's list. That's hearing appeal ending 2325 2671 North Douglas Street, Borda Khan.
okay, who's representing the city?
Good afternoon, Kristen Patchell on behalf of the city.
Good afternoon. Is anyone present? Any, 27 North Douglas? Y. Same on KHA. Anyone present? Okay, those responding.
Appellants matters listed 2671 North Douglas Street in their appeal, and notice of this hearing was provided to that address on 7/22/25.
Two 671 North Douglas Street, Zorba Khan. This matter is dismissed for failure to appear.
Dismiss for failure to appear.
Dismissed for failure to appear.
Dismissed for failure to appear.
Dismissed for failure to appear.
Thank you.
Bring your attention, sir, to item 11 on today's list. That's hearing appeal ending 2336 1232 South 45th Street, Martha Evans.
Okay, who's representing the city?
Jeffrey Cohen for the city.
Good afternoon. Martha Evans, 1232 South 45th Street, Martha Evans.
Yes, I'm here.
Okay, ma'am, do you have two devices on?
Yes.
Okay, you gotta turn one of them off because it's creating feedback.
Okay.
Okay, can you turn on your video? Okay, all right. Well, it was on, you turned it off again. Turn it back on.
There you go.
Okay, unmute yourself, ma'am. Thank you. Martha Evans, would you raise your right hand to be sworn? Do you swear or affirm the testimony you give today be the truth to help you God?
I do.
Thank you very much. Okay, all righty. Mr. Cohen, you represent the interest of the city.
Just briefly, the city sent out an exhibits packet to Ms. Evans and to this board. Exhibits 1 and 2 are the notice of violations from January 31st of this year and the batch notification that it was mailed out on January 31st of this year, which makes the appeal 3 months and 13 days late.
Okay, thank you. Ms. Evans, as you're aware, hopefully you're aware that the code provides for a 30-day appeal window, meaning 30 days after the date of the appeal. In this instance, your violation notice was January 31st, 2025. You did not submit an appeal until June 13th, 2025. Can you give us a reason as to why you did not submit appeal in a timely fashion?
Well, I haven't been receiving the notices. I don't live at the property, and I think the people there were manipulating the mail.
Okay,
For the
this
record-
address is 1232 South 45th Street. Is that the address you have on the city record?
That's a property we own in the city, and we own also 1232.
For
Both
the
of those
record, members
properties.
of the board, the notice went to 915 Allen Drive in Yaden, which is also the same address that Ms. Evans put on her Blur appeal form.
Okay, the address that the violation notices was sent to your Yaden address. You didn't receive the mail?
No.
Oh, okay.
Wait a second.
Okay, are you been having issues with receiving mail from the city?
Yes, sometimes they might send it. I don't live at the addresses, and that sometimes they send them there, and I don't get it.
Okay,
And
what I'm
also-
asking though, do you have issues receiving mail at the Yaden property where you live?
Yes.
Okay. Okay, anything else from the city?
Just that the mailbox rule and various case law on that is in the city's packet, exhibits C7 and C8. A mere denial of not receiving the mail isn't good enough to overcome the presumption it was received.
Okay, thank you. All righty. Any other questions from anyone?
Yes, Mr. Chairman, I have a question, and I'm just going to direct this to Mr. Cohen. The violations that I'm looking at are directed to a Quince E. Evans, not to Martha Evans.
Thank you,
Okay.
Board Member Penn. Exhibit C4 in the packet is the deed. It's actually co-owned by Martha and Quince Evans,
Okay.
husband and wife.
Okay, I'm sorry.
And-
Quince Evans's name is on the late request form, but Martha Evans is on the Blur appeal form.
Okay.
Okay.
Can I say something? Can I say
ma'am?
something?
No, and
Wait,
can
wait,
I
wait.
ask Miss Martha Evans that if she has someone else in the room who is giving her responses, that is unacceptable. She must answer the questions yourself from your own knowledge, not from someone else giving you answers.
No, I had to have someone to help me to get on the Zoom.
Yes,
That's
but
all.
I do hear someone speaking to you.
No, that was to help me get on the Zoom. But my husband, Quince Evans, is the.
Okay, wait, ma'am, Miss
Yes.
Evans, just for a
Yeah.
moment. Just be aware that these microphones are very, very, very sensitive. And we're
Right.
picking up voices, a voice, and we see you turning to speak to someone. So that means that there's someone else helping you with your answers. Okay, so that's why Board Member Penn raised that issue. Okay, now I do have a question for you. Is Quince Evans your husband, and should he be the one responding to our questions?
Well, my husband is 86 years old. He's a disabled veteran. So I've had to try to pick up things that he normally do.
Okay, all right. Okay, any other questions from anyone? Okay, ma'am, anything else before we vote?
No, we've had this property for a long time, I think since 1974, and we never had a problem until we had
Okay,
a
ma'am.
developer.
No,
Right.
no, no. Keep in mind that our only issue we're dealing with today is whether or not we should permit you to submit a late appeal. The
Okay.
underlying violation is not for discussion today. That would be at an appeal hearing if we grant your request, okay?
Okay. Mm-hmm.
Okay, so regarding HA 2025-002-336-1232 South 45th Street, Martha Evans, request for non-pro-tunc relief, denied.
Request denied.
Request denied.
Request denied.
Request denied.
Ms. Evans, we've denied your request to submit a late appeal. You may appeal our decisions if you choose to, and you can do that to Common Pleas Court. If you need information as to how to do that, call the administrator's office, and someone there will tell you what you need to do to appeal a decision of this board. Okay? Thank you very much for your participation. Have a good
Okay,
afternoon.
thank you.
I believe
Okay,
the
thank you.
appeal is Martha Evans as
Same
well.
appellant.
That's what I have on mine.
Okay, there's two, we have another matter?
Yes, sir.
Oh, my apologies. I didn't know.
That will be item number 12, hearing appeal ending 2337-420 North 53rd Street, Martha Evans.
Okay, who's representing the city in this matter?
Thank you. May it please the board, Leonard F. Reuter, City of Philadelphia.
Okay, Ms. Evans, are you going to speak regarding the appeal of this motor vehicle repair license violation?
Yeah, my husband normally takes care of that. Yes.
But are you going to testify today?
Yes.
Okay, you're still on the oath, okay?
Yes.
Alrighty. Now, again, this appeal is referencing to a violation notice that was dated June 8th, 2024. The appeal was not submitted until June 13th of 2025, about a year late. And so the issue is, why is it so late?
The problem is we still have problems. When they deliver mail, they deliver the mail at any place.
Okay, so your argument is that you didn't receive the mail in a timely fashion?
Right. And the
Who
lack
was-
of a notice.
Where was the mail delivered?
I really don't know where it was delivered. That's why we didn't get it.
So did you ever get the violation notice?
I think we got it sometime later, yes.
Do you have it with you in front of you now?
No.
Oh, you don't? Okay. Mr. Rowdy, any comment you'd like to make?
Again, similar to the last case, the violation notice here was, as the board noted, was issued June 8th of 2024. The violation was sent to the property owners, Quince and Martha Evans at the 915 Allen Drive, Yaden, PA 19050. Again, this was issued just over a year prior to the appeal having been filed. And I would note, as the board indicated or implied, this involves a business operation taking place at this location. And I guess if I had any questions to ask of Ms. Evans, is whether her or her husband own the business that's operating there, or is that a commercial tenant they have operating?
No, we don't, we own the building, but not the business.
Okay.
So is this an issue whether the business should have been cited, Mr. Rowdy?
I can check to see whether they were cited. However, again, the property owner is ultimately responsible in at any event. I can check to see.
Okay, well, we don't have an appeal before us from the property.
That's what I mean,
Yeah.
right? If there was no appeal from, let me just check very, very quickly. Now, we actually only have one violation notice that was issued, and that was to the property owners. So at the
Okay.
time, we didn't have, it may be well, as the violation suggests, it doesn't appear that the business was operating legally anyway. So I don't think we even have a name of the business.
Okay, all right, thank you.
Miss Evans?
Yes.
I just want to ask you, how many properties do you and or your husband own in the city of Philadelphia?
1, 2, 3.
Thank you.
Okay. Is there anything else from anyone? Any additional questions from
Yes,
anyone?
I have a question for Ms. Evans. Ms. Evans, on your application for the review, you say all violations have been corrected, but then you say you didn't get any notice of the violations. So how did you know to correct the violations? And when was the correction made?
I got the notices late.
When were the violations corrected?
Okay, one was corrected when they said that we couldn't have anyone in the property.
No, I'm not asking you for that. I'm asking you for a date as to when the violations were corrected.
Okay, we're continuously correcting the violations now.
And when did you learn about the violations?
I'm trying to think when we learned about them. Let me see, I have some things here. We filed the appeal in June.
I understand when you file the appeal. My question is, when did you learn of the violations and start making the repairs? You're telling us now everything's been repaired. How is that possible?
About 2 months. About 2 months.
2 months what?
That we started making the repairs.
So you're telling us that you've made repairs between June and September?
We started making repairs on, tell you the truth, I'm a little confused. We started making repairs just recently, yes.
Okay. All right. Thank you. No more questions.
Okay, thank you very much. We will poll the board regarding HA 2025-002337, 420 North 53rd Street, Martha Evans. Request for non-pro-tunc relief, denied.
Request denied. Request denied.
Request denied.
Request denied.
Okay, Ms. Evans, the vote is unanimous, request denied. So your appeal will be dismissed for being untimely. You may appeal our decision. Of course, as I stated earlier, if you need information as to how to do that, call the office and someone there will give you information that you need to submit your appeal. Thank you very much.
Okay, thank you. Okay.
Thank you.
Well, was that next matter?
Calling your attention, sir, to item 13 on today's list. That's hearing appeal ending 2355-1002 West York Street, New York Famous Euros Incorporated.
Okay, who's representing the city?
Good afternoon, Amy Skiles, Skiles, on behalf of the city of Philadelphia.
Okay, is Mr. McElhenney present?
I'm here, Mr. Chairman.
Okay, are you representing New York's Famous Gyros, Inc.?
That's correct. And my client Ikram Rashid is on the Zoom as well.
Okay, will you plan to call him as a witness?
Only if necessary.
Okay, all righty. As we've done earlier, the issue here is that the violation was dated July 30th, 2024. The appeal was submitted June 13th, 2025, which is slightly less than a year late. So, Mr. McElhenney, what is your argument regarding the late appeal?
Mr. Chairman, can you say those dates again? I have a letter violation April 1st, 2025.
Well, the date in our record is July 30th of 2024. Ms. Skiles probably has the record. She can put it up on the screen, I believe.
I can.
I can.
Yeah.
I'm wondering if this is a different appeal.
This is HA 2025-002355.
I need to sign it though.
This is I apologize, members of the board. This is a different appeal. This is an appeal to Unlimited Holdings, Inc. at 3000 Sedgley Ave. I thought
Okay.
this was, I have a notice of appeal. I thought it was for a vending cart violation for NY Famous Gyro that's on the north side of Spruce Street at 37th and 38th.
Okay, so do we have a mistake in the record in terms of who should be standing before us today?
Let me stop.
Just hold on for a moment, Mr. McElhenney. We'll figure this out.
Sure. My client used to have his cart at that Sedgley Street address, but L and I shut it down.
Okay, Mr. McElhenney, do you represent the owners of 1002 West York Street?
That is the Rashid family, and NY Famous Gyro.
Okay,
I'm not sure who the titled owner is on the deed, but yes, that's where the carts are currently located. And
okay.
Just a minute.
And from your perspective, this is a vending cart violation matter, not a food caterer license, or maybe it's the same.
they're interrelated in that my client left the Sedgley Street address to go to York Street, and I have a violation dated April 1st, 2025 from Miss Blaney. We had to email her because it went to the Sedgley address that we were told to vacate, and we did. So once Miss Blaney gave us the notice, I filed the appeal. We were lacking our neighborhood vending license, which we've since renewed.
So I pulled up the appeal paperwork for this appeal, HA 2025-02355, and attached to this appeal is the violation notice CF 2024-081-059, which was issued July 30th, 2024, for violations that occurred at 3000 West Sedgley. So the city was under the impression that was the appeal before the board today, that violation, not of.
Could we, I guess, could I request a continuance and I can try to work with the city to have these both properly scheduled? Because I did attach that violation to my appeal. Because I was showing the reason we didn't file the appeal is it went to this old address that the city shut down.
Okay, how about this? Was there any value to the two of you in a breakout room discussing it?
Oh, sure.
Is there a way to resolve it today potentially before we end things and come back?
I'm happy to, I can't guarantee we can resolve it, but I'm happy to have a discussion.
Yes, let's have that discussion if we can. I prefer to get somewhere today than to leave it in the record and it gets all confused going forward. So we will put you in a breakout room, Mr. McElhenney, to see if we can, what can be worked out, okay?
You should see room 3, sir.
Room 3, Mr. McElhenney. Okay. What is our next matter?
Next matter on the list, sir, would be item number 16 on today's list. That's hearing appeal ending 2380-4917 Pine Street. Jordana Kostic, doing business as Logos Plus.
Okay, anyone present representing Logos Plus? Okay, who's representing the city?
Good afternoon, Kristen Patchell for the city.
Good afternoon. Anyone present representing the interests of 4917 Pine Street?
I am here. I am not doing it as Logos Plus. I do own Logos Plus, but I never had anything with it.
We need you to give us your name. We don't know who you are.
Gordana Ana Kostic. This is how I'm the property owner, and everything goes with that name.
Okay, now this is an LLC, and so is there an attorney representing your interests?
No, this is not an LLC. There was no attorney. I am a sole proprietor. Everything has always been filed like that, and I always represent myself.
Okay, Ms. Patchell, any response to that?
No, the violation was issued to Ms. Kostic.
Okay, all right, so there's no issue of standing then. Okay. All righty, ma'am. The issue here, though, is whether or not you should be permitted to submit a late appeal. And so the dates that we're working with is that April 30th, 2025 is when the violation was written. and you submitted an appeal on June 17th, 2025, which is roughly 60 days late.
Yes.
Excuse me, Chair, pardon the interruption. Do not believe that Ms. Kostic was sworn.
Yeah, you're absolutely correct. Ms. Kosich, would you raise your right hand? Do you swear or affirm the testimony you give today be the truth to help you God?
I do.
Thank you very much. Thank you, Mr. Kelly. Okay, let's proceed. Ma'am, what is your response to my previous question?
Yeah, I learned about this violation when I was completing my primary violation. This is the kind of second version of secondary violation resulting from my primary violation. I was not informed on the primary violation on timing, all right? And I never received this. I never knew when I learned about this violation when I went to the LNI to pay my dues on the primary violation.
Okay.
I had
Now, okay,
so
ma'am.
I cannot, I'm sorry, but I cannot respond for something that I don't receive.
Well,
So I
let us ask you a few questions.
Yeah.
Your argument is that you did receive it, and I guess the question here, and Ms. Patchell may have additional questions for you. 4917 Pine Street, is that the mailing address?
No,
Okay. What is the mailing address on the violation?
where I reside and where I can receive things timely and respond timely is 321 South 46th Street. 4917 is my rental property, is registered at 2 apartments and not owner occupied. So
Okay, well, wait. The record does indicate that the violation was mailed to your mailing address. It was sent to your residence. That's according to the record. Okay, Ms.
I
Patchell?
did not receive that.
Okay,
And that
all
is
right. Well,
interesting.
let's wait for a moment now. Ms. Patchell may have some questions for you.
Right.
Chairman Woodson, the city doesn't have any questions for the appellant. The city would just point out that the site violation notice was addressed to Ms. Kostich's address that she puts on her appeal paperwork. It's almost 7 weeks late. So the city would argue that she did not meet her burden.
Okay, any other questions? No additional questions from anyone already? Ma'am, Ms. Carson, we will vote on this matter soon. This is an SVN. So, ma'am, how did you learn of the violation? I'm curious.
I came on, I was working on my, and finally completed the primary violation. So I was down at licenses and inspections trying to pay my dues, the final thing, so that I could actually pay these rental rental licenses that I couldn't pay before, although I was trying and asking, why wouldn't I be able to pay that? Because my original violation wasn't affecting it actually. And I was always told that, you know, this is not possible because I do have just the fact that I have that violation. So it was finally, and the first thing that I did after it was possible was to, you know, sort out the rental licenses. So there was no way for me, because all the time I'm trying to pay for it. There is no point for me not wanting to pay if I am ever offered that. I did not receive also, I don't think that I know that I didn't receive because I would react. Okay, I didn't receive, there was a violation issued to me on something else. The water leak, supposedly that ended up not being on my pipe whatsoever, but it came to 4917 Pine Street. That's why I was believing that this also came to 4917. And luckily, someone there was able to see that as an important, possibly important mail and warn me about it. So then I, of course, you know, I was able to act on that.
Sure.
But, you know, it's not that I don't want to act on something
We
also.
understood. Wait. No.
Just a second,
Listen to me,
please.
ma'am. Listen to me. We have a limited amount of time to hear an incredible list of cases. So you've said that, so we've heard you, but we just need to bring some clarity to this. How long have you owned those rental properties at 4917 Pine Street?
I bought it in 2005.
And
It's
you
one,
you've renewed your rental license on a regular basis?
yes, from 2015.
Okay, and so you realize that your rental license had expired?
Yes, I couldn't renew it because I had the other violation that was taking forever, to take care of.
Okay, all right, thank you very much.
But let me just tell you this,
No,
there
no,
was
ma'am,
the same violation.
Ma'am,
Okay.
we get to decide the flow of this thing, okay? We've heard you. Unless you are prepared to offer brand new information that we have not heard yet. You have something brand new that we haven't heard?
Yes, this is brand new for you to not have heard. The same violation on the lesser fine the year before, it took like 2 years for this, okay? I had a relief on 4/8 for that violation. In the meantime, they're sending me within a month, although it's the exact same violation, not having a rental license. I receive it on the 29th of April again.
Okay. All right.
And I don't know about it till I come to, pay everything that is needed so I can do renewal rental licenses. And then I hear that there is one that was instead of like $300, $1,000, and that is a separate violation. I thought I was still under relief.
Okay, this goes not to the issue of tardiness, which is the only thing we're talking about today, is whether or not you filed a timely appeal, and the issue is that the facts indicate that you didn't. Now we need to decide if we will permit you to submit a late appeal. If we say no, then your appeal will be dismissed. If we say yes, then an appeal will be scheduled. Anything else from anyone before we vote?
We have an executive session, a brief one.
Okay, brief. Back on the record. Ms. Patchell,
Yes.
question for you. Do you have any evidence that this actual violation was mailed?
All I have is a copy of the violation that would have been in the Eclipse system. I have, well, not even an SVN. I have a copy of the site violation notice. That's all I have.
Okay, all right, thank you. Anything else from anyone before we vote? Okay. Just one moment. All right. Thank you. Regarding HA 2025-002380, 4917 Pine Street, Gordana Kostic, DBA Locals Plus LLC. Request for a non-pro-tunc relief denied.
Request granted. Relief denied.
Relief denied.
Relief denied.
Okay, thank you, Ms. Kostic. The vote is to deny your request to submit a late appeal. You may appeal our decision. And of course, if you need information as to how to appeal our decision, check with the administrator's office and they will give you what information you need. Thank you very much for your participation today. Okay, let's move on to our next matter.
Next matter on the list, sir, is item 20, hearing appeal ending 2442, 1643 South Udall Street, Jessica Breeden.
Okay, who's representing the city?
Good afternoon, Board. Caitlin Carmody on behalf of the city.
Okay, anyone present representing the interests of 1643 South Udall Street? Jessica Breeden. Anyone?
Yes,
present?
I'm here.
Oh, okay, thank you very much, ma'am. If you raise your right hand to be sworn, do you swear
Yes, sir.
affirm testimony you give today be the truth so help you God?
Yes.
Okay, thank you. Alrighty, Ms. Patchell? Yes.
Carmody.
Carmody, my apologies.
That's okay.
It's been a long day. Ms. Carmody, my apologies. Okay, Ms. Breeden, the issue here is whether or not to grant your request to submit a late appeal application. according to our records, the violation was written May 21st, 2025. Your appeal was submitted June 23rd, 2025. And so you're slightly over the 30-day window. So what is your defense for not submitting a timely appeal?
I went on the 20th to submit it, but the people had left early, so I'm not sure if it was because the city probably was closed June 19th, so they took an early leave. But I was there, I was present,
I'm sorry.
and nobody was there to do the appeal because I already was at LNI 3 times earlier that week for a different instance. So when I went to that particular, 43, wherever the desk is at, nobody was there. They told me it was closed down because everybody left early for the day. And I was there at a adamant time. I'm pretty sure I could probably check the books where
Now,
we sign
what
in at
time
and
were
they
you
scan our
there?
IDs.
What time
Huh?
were you there? What time did you?
I was there
attempt to-
around 2 o'clock.
And there was no one at the office at 2 o'clock on the 20th?
Yes, in that particular office where you file the appeals. The opposite side of LNI, they were still there late because I already was dealing with a different issue with LNI with my Ritter's license for a different property. But when I had went to the other side, it was already closed.
Okay, I'm not sure why that would happen. You didn't attempt to submit your appeal online?
I thought I had to do it in person. That's why I went down there. I was handling all my affairs basically in person.
Okay.
So I wouldn't have no issues with anything. And also if I needed, I had a couple questions to ask. So I figured it'd be easier in person for me to get all the help that I could.
Any response from the city?
The city's position today, based on the notice of violation, the appeal due date would have been June 20th. That said, it's the city's position that it is late, albeit by a few days. It is also the city's position that in this instance, the city would not be prejudiced by granting the late appeal. But I would just say for the board that there was a full 30-day period. Ms. Breeden, it does appear, waited until the last day to file the appeal, but I would defer to the board's discretion.
Okay, thank you very much. Anyone else? Okay, HA 25-002442, 1643 South Udall Street, Jessica Breeden, request for non-pro-tunc relief granted.
Request granted. Request granted.
Request granted.
Request granted.
Okay, Ms. Breeden, your request to submit a late appeal has been granted. A scheduled appearing will be scheduled, and you will receive notice in the mail.
All right,
Okay?
thank you, everybody. Have a good day.
You're welcome. Have a good day.
Thanks. Bye.
Thank you, members of the board.
Okay, what do we have next?
Sir, if I could call your attention to item 4 on today's list, that's hearing appeal ending 1261 11750 Bustleton Avenue, East Coast Electrical Services Incorporated. Joseph Bernaducci is the attorney.
Okay, and who's representing the city?
Good afternoon again, Kristen Patchell for the city.
Afternoon, Ms. Patchell. Counsel for the appellant present? Anyone present representing the interests of 11750 Bustleton Avenue, East Coast Electrical Services, Inc.?
He is on the call, sir.
I just had to unmute myself. I'm sorry, Mr. Chairman.
Okay.
My name is Joseph Bernaducci. I'm appearing in behalf of the appellant.
All right, good afternoon, sir. As you've heard, we're here, of course, to consider the request for a non-pro-tunc relief in this matter. According to our records, the violations were written January 17th, 25. The appeal was not submitted until April 7th, 25. More than 30 days beyond the original date offered in the code. Any argument in defense?
Yes,
of
I
that?
have one witness, Mr. Chairman. And that would be Andrei Pilipenko, who is the owner of the LLC, the appellant in this case. I would call him as a witness.
Okay, Mr. Pilipenko, if you raise your right hand to be sworn. Do you swear or affirm the testimony you give today be the truth to help you God?
Yes, sir.
Thank you. Just, you may lower your hand. Just for the record, I just wanted, it appears that you're in a vehicle, Mr. Pilipenko. Are you parked in a safe place?
Yeah, I am parked at the gas station.
Okay, thank you. All right, according to the record,
Mayor Park.
that the-
I'm sorry, I see things moving in your rear window, Mr. Pilipenko. Are,
Look,
I believe that was,
okay,
That was a
my apologies,
pedestrian.
there's probably a vehicle moving behind you. Okay, my
yeah,
apologies.
probably.
okay.
No
Mr.
problem.
Bonaducci, you wanted to call on your witness?
Yes, I call Mr. Pilipenko. He's been sworn in. Mr. Pilipenko, what is your relationship with the appellant East Coast Electrical Services?
I am the president of this company.
Okay. It's an LLC, is that correct?
No, it's S Corporation.
Corporation, okay. C Corporation, all right. You filed your appeal of the notice of violation approximately 4 months late. Can you explain to the board members what occurred and why you filed late? Go ahead.
Okay, the reason why, because the board sent it to the old mailing address, 4400 Old Lincoln Highway, and my new mailing address is at 11238 Lockhart Road, Philadelphia, PA 19116, and I never got my citation on time.
Okay, and was your new address registered with LNI? Did you report the change of address?
Yes, sir. Yes, I did with LNI office.
Okay, and how did it occur that you finally did get the notice? What happened? How'd you find out?
It's actually one of my customers. I have been informed by one of my customers. They went online to add me to this new job, and they noticed I have a violation, and I have been informed by them. So I went online and I checked it, and I did have a citation for 11750 Bustleton Avenue.
Right.
So as soon as I find out, I went to LNI to apply for a hearing.
Okay. How much time between the time that you went online and confirmed that you had a notice of violation and the day that you went down to file your appeal? How much time elapsed? How long did you wait?
I'm sorry, can you repeat the question?
Sure. How long did you wait to file your appeal after you found out that you had a notice of violation on record at LNI?
And the very next business day.
I'm sorry, I couldn't hear you.
Yeah, as soon as I find out, I went to I actually made an appointment with LNI and the next business day.
The next business day, okay. And you then successfully filed your appeal on that day, right?
Yeah.
Okay.
Yes, I did.
I have no other questions, Mr. Chairman.
Okay, thank you. Any cross?
Just briefly, Mr. Sir, you filed this in April of 2025, the late appeal, is that correct?
I couldn't hear the question. I'm sorry. Could I have the question repeated, Mr.
Sure.
Chairman?
You filed this appeal on April 7th, 2025, is that correct?
Believe so.
Okay, and you have a electrical license, correct?
Electrical license, yes.
Okay, would you recognize a copy of it if you saw it?
I didn't hear the question
Yeah.
again. I'm sorry. I'm having trouble hearing your questions, counsel. May I
Would
have it
you-
repeated, Mr. Chairman?
Would you recognize a copy of your electrical license if you saw it?
Would I yeah, I mean, I remember my license number if you want me to say it out loud.
Permission to share my screen.
Yes, please share your screen.
Do you see your license on the screen, Mr. Piplenko?
Yeah,
Okay, you see your name
yeah,
and you see 4400 Old Lincoln Highway?
yeah.
Okay.
Mr.
and-
Chairman, I'll stipulate that that's what the document shows.
Okay, and this was,
Okay, so noted.
and just one more point, sorry, this was issued in July of 2024 and was supposedly good until June of 2025. Is that fair to say?
Can't hear.
This license
Could
was
I have the
valid
question
until,
Yeah,
repeated,
she's
Mr.
repeating it.
Chairman?
She's repeating.
this license was valid until June of 2025, correct?
Yes.
Thank you. I don't have anything further.
Okay, I had one question, sir. When did you submit to the department your change of address?
Well, I actually had a issue changing the address, but I submitted. I don't recall it, like few months ago.
Okay, so you submitted your change of address after.
Yeah, unfortunately, I'm sorry. Yeah, unfortunately, it's really hard to change something with LNI or update something with LNI.
Okay, well, I'm asking this
I was-
question. Wait a minute. I'm asking this question because your counsel is arguing that you submitted a change of address and therefore it's possible that the violation went to the wrong address. But I believe what you've just said, that you didn't submit your change of address until a few months ago. It is now September. So that would have been July, August. Am I accurate?
No.
Okay,
No.
when did you submit your change of address?
I mean, it's been, I don't know, a few months ago, like 4 or 5 months ago, maybe 6 months ago.
Okay, thank you. Anyone else have anything?
I have
Okay.
nothing further, Mr.
All right,
Chairman.
thank you.
I would just mark that license as C1. I'll send it to the board after.
Thank you. So submitted. All right, regarding HA 2025-001261, 11750 Bustleton Avenue, East Coast Electrical Services, Inc. Request for non-pro tunc relief denied. Turn it on.
Request granted, relief denied.
Miss Penn, you're muted.
My apologies. Relief denied.
Relief granted.
Okay, there's 3 votes to deny, 2 votes to a grant, and so the deny prevails. So, sir, in this instance, your request for non-pro tunc relief has been denied. You, of course, may appeal our decision. Mr. Bennett, Berarducci, you're, I'm sure, very familiar with that process. Thank you very
Yes.
much. Have a
My
good
excuse.
afternoon.
Am I excused,
right,
Mr.
thank you.
Chairman?
Okay, what do we have next?
Yes, sir, you are excused. I
Thank
don't
you.
believe the chairman heard you.
I didn't hear you. My apologies. You're
Thank you,
excused.
thank
The
you.
witnesses are excused as well.
Sir, I'd like to call your attention to item 33 on today's list. That's hearing appeal ending 2638 for 3430 North Bodine Street. Lucero Chismudez. Natalie Calistorni is the attorney, and we do have a Spanish interpreter online for this matter, sir.
Okay,
Hello, this
with
is
the
Karen.
interpreter, please identify yourself.
Yes, my name is Karen Lopez and I will be your Spanish interpreter. Are you able to hear me well?
Yes.
Okay,
Just for a
wonderful.
moment, we'll swear you in a moment. Give me a moment.
Take your time.
Good afternoon, members of the board. My name is Amanda Dougherty, Dougherty. I am with Natalie Clistorni's office, and I'm appearing for the appellants today.
Okay.
I did actually had the chance to speak with Miss Skiles in a breakout room before her battery died. And I think we may in fact have an agreement. I just need to discuss it with my client. If I could have a moment in a breakout room with Miss Andrea Fernandez Chismudez, her daughter, who speaks English.
Okay.
Sorry, my computer died before I could fully look into this.
Okay, let's
fully-
do this.
But if I,
Well, no, wait. We need an interpreter. We have one here, so we need to have the interpreter interpret. And so the interpreter is, I believe, Karen Lopez. Ms. Lopez, please unmute, raise your right hand. so we may swear you. Do you swear or affirm that you will faithfully translate from English to Spanish, Spanish to English, all matters that are spoken regarding this matter concerning 3430 North Bodine Street?
I do.
All right, thank you. Now, let's begin again. Madam, the interpreter, I'd like you, anything that's said in English, please interpret in Spanish, and then all of us will be patient enough to allow you to do that, okay?
Sounds good.
Ms. Skiles, just put your name on the record and we will begin there.
Yes, good afternoon, Amy Skiles, Skiles, on behalf of the city of Philadelphia.
Buenas tardes, la señora Amy Skiles, en nombre de la ciudad de Filadelfia.
Amanda Doherty, Dougherty, on behalf of appellant property owner Lucero Chesmudes.
Amanda Diori, de parte de la apelante, la recurrente, la propietaria Lucero Chesmes.
Okay, I believe that the parties are at the point of agreement.
I am.
Me parece que ambas partes están a punto de llegar a un acuerdo.
I thought we might be able to have a resolution on this. My computer died before I was able to talk to Ms. Doherty a little further, but the city's unable to resolve this matter. I can explain further in a breakout room to Ms. Doherty if the board wishes.
Okay.
Pensaba que ya habíamos llegado a una solución. Mi computadora se apagó antes de que pudiera hablar con la señora, pero la ciudad no puede resolver este asunto. Puedo explicarle más detalladamente este asunto a la señora Doherty en una sala de reuniones.
So for purposes of this request for non-pro-tunc relief, should we proceed or is there a possibility of that being resolved?
I don't.
¿Esta solicitud de alivio no protónico debe procesarse o existe la posibilidad de que se resuelva?
The city can't enter a resolution today.
La ciudad no puede permitir una solución el día de hoy.
Well, so the other question would be to the council, to both councils, should we continue this for another time? Hopefully there's a conversation that will resolve matters if we continued it.
La siguiente pregunta es para los abogados. ¿Deberíamos continuar con esto en otra ocasión o van a hablar sobre la resolución del asunto antes de que se continúe?
The city's ready to proceed. It would be our request to proceed today. That would be the city's request.
Okay.
La petición de la ciudad es que está lista para proceder.
Counsel for the appellant?
That's fine then.
Está bien, procedamos.
Okay, all right, we'll proceed with this non-pro-tunc hearing for this matter.
Vamos a proceder entonces con esta solicitud no protónica para este asunto.
Okay, ma'am, would you give us your name again? I apologize, I didn't write it down clearly, so I want to make sure I pronounce it correctly. Yes, ma'am.
My name
Yes.
is Amanda, Amanda, Doherty, Dougherty.
Okay. Ananda Doherty. Am I correct?
Correct. I'm from Oklahoma and I think it's a regional thing.
Okay, all right, thank you. Okay, all right, let's proceed then. Of course, according to our record, the violation was written on 2/25/25, and the appeal was not submitted until 7/9/25, considerably after the 30-day window for appeals. And ma'am, Ms. Doherty, what is your defense argument? The interpreter should be interpreting what I said.
Por supuesto, el acta dice que la violación fue escrita el 2/25/25 y la apelación no fue presentada hasta el 7/9/25, considerablemente después de la ventana de 30 días para apelaciones. ¿Qué tiene que decir usted, señora abogada Doherty?
So in brief, I would say that the issue was Ms. Chesmudes received the notice at some point in late February, perhaps the 25th or shortly thereafter, and had been working with a processor regarding acquisition of 3432 as a side yard.
La señora recibió una notificación en algún momento al finales de febrero, tal vez el 25 o poco después, y después había estado trabajando con el procesador con respecto a la adquisición de 3432 como patio lateral.
She One took it to her daughter, Andrea Fernandez Chesmudes, who is also here today.
Lo llevó a su hija Andrea Fernández Esmuez, que también está presente aquí el día de hoy.
She got the general gist of it with her husband, Mr. Fernandez, and then they went to the expediter with whom they had been working, Mr. Livio Matos.
Ella, bueno, obtuvieron la idea general del asunto junto con su esposo, el señor Fernández, que también está aquí. Luego fueron al expedidor con quien han estado trabajando, along with Mr. Matos, you said?
Yes.
Con el señor Matos.
They were able to contact him sometime in mid to late March.
Pudieron contactarlo en algún momento a mediados y finales de marzo.
They were able to contact him and he informed them that he would take care of it, what needed to be done to address it, and they didn't need to worry about it.
Pudieron contactarse con él y él les informó que sería a cargo de lo que fuera necesario para solucionarlo y no tenían que preocuparse por eso.
Problematically, he became very difficult to get a hold of. He had been difficult to get a hold of and then completely fell off the map, and they have not heard from him since mid-March of this year.
Problemáticamente era difícil comunicarse con él, había sido difícil contactar con él y luego desapareció por completo del mapa y no han sabido nada de él desde mediados de marzo de este año.
Because though he had been a bit difficult to get a hold of, they also kept reaching out, and they tried to reach out to Councilmember Lozado's office.
Ya que había sido difícil comunicarse con él, también siguieron intentando comunicarse, trataron de comunicarse con la oficina del concejal Lozano.
If I may share my screen. Oh dear, one moment.
Un momento.
Well, I'll share my screen in a
Well,
moment.
before you do that, the issue here is the argument for why the appeal was tardy. And
Yes.
so.
I'm
is
sorry,
it-
sir, you cut out. Do you mind saying that again?
Yes, the issue here is squarely
Sir,
should
can
be
you hear me?
focused on why the appeal was tardy. Did you hear that, interpreter? Did you hear that, interpreter? Okay, we may have lost the interpreter. I think the interpreter is frozen.
She never had a picture up that, or she never had video up. That was only a picture.
Yeah.
Spanish interpreter, can you hear me?
Okay.
I'm bringing her back in now. Looks like she dropped off the call.
To keep the case moving, I'm the
Okay,
daughter,
wait a minute. Who's speaking?
Andrea Fernandez. I'm the daughter of Lucero.
No, you can't speak out that way, okay?
Sorry about that.
You have a lawyer who's representing you, so you need to call her or talk to her.
Ms. Doherty, this is Matthew Webster, Board Counsel.
I believe Ms. Doherty's rejoining again as well. She just joined again.
Sorry, I've been here, but I was going to share my,
Okay,
I
before
was
you
trying
do
to figure
that.
out how to share my screen. Sorry.
Before you do that, we've lost the interpreter. Also, I believe Ms. Andrea Fernandez Chesmudes wants to talk to you regarding something she wants to share. So you may want to, we can put you two in the breakout room if that would help, unless she's in your office.
Mr. Chair, I have a quick question for Ms.
Yeah.
Doherty that may resolve
Yes.
this. Is the appellant present?
Yes, Lucero is here. She's on mute. She's muted. You need to unmute.
Okay. I misunderstood. I thought that the appellant had chosen not to appear today. My mistake.
Nope.
Okay. If you want to speak to Ms. Fernandez, we can accommodate the two of you and put you in the breakout room. Do you want to do that?
I believe, Ms. Fernandez, you were going to try to speak for your mother. And if that was the case, then no, we don't need that.
Okay, we are waiting for the interpreter to return.
Someone is joining now. I believe it's the interpreter, sir.
When the interpreter gets back, did we want to swear Ms. Lucero Chesmudes?
Only if you plan to call her as a witness.
I am very sorry. I got disconnected. I am back. This is the Spanish interpreter.
Okay. Also, we need your actual image, not a photograph.
I don't have a camera right now. I'm so sorry. Is that going to be an issue?
Yes.
My apologies. I don't have a camera right now.
You don't have a camera at all?
No, sir.
Okay. Any concern from law department?
We would have no objection to continuing the matter for the purposes of an interpreter for today.
Okay. All right. Just as a general comment, though, we would prefer to see the image of the individual who's participating in these proceedings, including interpreters.
Solamente como un comentario, preferimos ver las imágenes de las personas que participan en estos procedimientos, inclusive los intérpretes. Yes, sir. I apologize for that.
And Ms. Darkany, you were proposing to share documents, and I interrupted you because I just wanted to remind all of us that we want you to focus on why the application was tardy and not the underlying violations, okay?
Señora, usted nos mostró unos documentos, pero quiero comentarle, quiero repetirle, recalcarle que nosotros no queremos basarnos en las documentaciones que nos quieren presentar, sino en la solicitud y por qué se dieron las infracciones, no solamente las infracciones subyacentes. De acuerdo.
And that is, yes, that is what I did intend to, the only thing I intend to focus on.
Sí, y eso es lo que tengo o pretendo centrarme.
As I was mentioning, because Mr. Matos had been difficult to get a hold of, and given the intersection of the side yard and violation issues, Lucero, here is her email, Lucero Fernandez, Lucero Chesmudes. As you can see, sent an email in Spanish to one of Councilmember Lozada's staff, Xiomara Santiago.
Ya que era difícil contactarse con el señor Lozada, como puede ver aquí, la señora Lucero Fernández contactó a la intercepción del patio lateral y los problemas de violación. Como puede ver aquí, mandó un correo el día lunes, martes 24 del presente año a la señora Xiomara Santiago.
Okay, Ms. Darnay, I'm not certain how this helps us. So would you give some clarity as to how this helps us understand this issue?
¿Me puede explicar cómo nos ayuda esto a resolver o comprender este problema?
Yes, sir. So the appellant, Ms. Chesmudes, had the promise of an expediter that the expediter would handle the violation and do what needed to be done, which is to say, appeal it. The fact is for a non-proton, the appellant has to show non-negligent circumstances or a breakdown in the administration. While she received the notice, she had non-negligent circumstances because she did ask an expediter who promised her he could take care of this.
Can you please pause?
Yes, ma'am.
El expedidor que gestiona la infracción dijo que haría lo necesario, simplemente apelando. De hecho, para que no haya problema, la apelante debe mostrar circunstancias no negligentes o un fallo administrativo al recibir la notificación. No tiene circunstancias negligentes porque le pidió que se encargara de esto.
I forget what I last said, but I would suggest that it's non-negligent circumstances that she took action and requested someone who had a better understanding. She's a first-time homeowner, a better understanding of the system, who promised her he would take care of it, and she relied on that promise. She thereafter still didn't purely rely on that promise because she also reached out to a city council member's office to ask questions. This was sent March 24th, 2025.
The interpreter, please.
Por eso queremos poner esto como algo que no es negligente. Cuando se comprometió, no se comprometió mejor con el sistema. Ella Es la primera vez que era propietaria. Le prometió que se encargaría del asunto y ella confió en esa promesa. Posteriormente, no confió plenamente en esas promesas, ya que también contactó con la oficina de un concejal para hacer preguntas, como puede ver aquí, el día lunes 24 del 2025.
That shows she was taking action and prompt action at that.
Eso muestra que ella estaba tomando acción y acción rápida.
She could not get a hold of the council member, and as I said, she could not get a hold in that month after with Mr. Matos.
Ella no pudo contactarse o tener contacto con el miembro del consejo y, como dijeron, también no pudo comunicarse ese mes con el señor Matos.
She then went to Councilmember Lozada's office, got Miss Santiago's card to show it, had a conversation with her, and it was only in April 30th that she was able to do that.
Ella, como no pudo contactarse, accedió a la localidad, encontró el nombre de la señora Xiomara, cogió la tarjeta como prueba de ello, para demostrar que tuvo una conversación con ella, como se ve aquí perpetrado. And did you provide a date for that?
I'm sorry?
Did you provide a date for this email that you're showing? I'm sorry.
April 30th, 2025.
El 30 de abril del 2025.
She, as she does, because she's a non-native English speaker, relied on her daughter, Andrea Fernandez. And on May 2nd, Ms. Fernandez informed the council member that there was possible misinterpretations because of Ms. Chesmudez's language barrier.
Ya que la señora no habla inglés como una barrera del idioma, acudió a su hija Andrea Fernández para que le ayude con la interpretación. Después se pudo comentar o se informó al miembro del consejo, la señora Fernández, que tal vez hubo alguna mala interpretación, no se interpretaron bien las cosas ya que hubo la barrera del idioma.
That was in early May 2025, and she was not able to get a hold of the council members staffer again until I think mid or late May 2025.
Eso fue a inicios de mayo de 2025. No pudo contactar a los miembros del consejo. El personal volvió a trabajar hasta mediados o finales de mayo de 2025.
At that point, it was made clear that Ms. Chesmudez had misunderstood that she had been told there was some lawsuit against her, and instead she needed to address the violation.
En ese momento quedó claro que la señora Chesmudez había malinterpretado la situación. Le habían dicho que había una demanda en su contra y que en cambio debía abordar la infracción.
And that Mr. Matos had not done anything to address the violation.
Y que el señor Matos no había hecho nada para poder llevar a cabo la violación o solucionar la violación.
She eventually found her way to an attorney, Mr. Addis, Dan Addis.
Eventualmente ella encontró al abogado, el señor Addis.
And at the end of June, came to our office on his advice because we handle this sort of thing.
Y al final de junio vino a nuestra oficina por consejo suyo porque nosotros manejamos ese tipo de cosas.
The appeal was then filed within a couple of weeks just after the July 4th holiday.
La apelación fue, excuse me, la apelación se presentó un par de semanas después, justo después del feriado del 4 de julio.
And if you need, I would ask where I could have my client could be sworn and adopt this testimony as her own for your consideration in terms of the timeline to show that there are non-negligent circumstances, that she was diligent during this time. She did rely on the promise of someone, but when she found out that that trust was misplaced, she acted promptly to bring this appeal non-pro-tunc.
Y si usted necesita, le puedo preguntar a mi clienta que preste juramento y presentar este testimonio para su consideración, considerando el plazo para demostrar de que no hubo negligencia y que actuó con diligencia durante este tiempo. Confió en la promesa de alguien, pero cuando descubrió que esa confianza era la que estaba en ese lugar y que se convirtió en un problema, para demostrar que fue algo no protónico.
Is she present to be sworn?
¿Está presente para juramentación?
Yes, Lucero, could you unmute yourself?
Lucero, ¿puede sacarse de silencio?
Sí.
Yeah.
Ma'am, give us your name, then raise your right hand to be sworn.
Denos su mano, suba su mano derecha, danos su nombre para que podamos hacer la juramentación.
Your name?
Su nombre.
Lucero Chesmudis.
Do you swear or affirm the testimony you give today be the truth to help you God?
¿Usted jura y afirma que el testimonio que va a dar el día de hoy va a ser solamente la verdad?
Sí.
Yes.
Okay, you place your hand down.
Puede bajar la mano.
Okay. Ms. Doherty?
Ms. Chesmudis, did you understand what I just said to the board as translated?
Señora Chesmudis, ¿usted ha entendido lo que le acabo de decir a la Junta tal como se ha traducido?
Sí.
Yes.
Do you wish to correct anything or would you adopt that testimony as your own?
¿Quiere corregir algo o quiere adoptar ese testimonio como propio?
Ah, no quiero corregir nada y creo que es lo correcto que está diciendo ella.
I don't need to correct anything. Everything is correct.
Okay. Do we have any, Ms. Giles, do we have any cross-examination?
No cross, I'll just make argument.
Okay.
No tenemos ningún interrogatorio.
Okay,
Solamente
I do have a question though. And Ms. Chesmudis, is there anyone else in your family who is fluent English speakers?
Señora Chesmudis, ¿hay alguien en su familia que sea fluido en hablar inglés?
Mis hijas.
My daughters.
Okay. Did they read the violations?
¿Leyeron las violaciones?
Mi hija Andrea, sí, es quien me ha estado explicando y traduciendo.
My daughter Andrea has been the one reading it to me and translating.
Okay, so in that violation notice, it tells you you have 30 days to submit an appeal, correct?
En esta notificación de violación le indica que tiene 30 días para presentar una apelación, ¿correcto?
Sí.
Yes.
Okay, thank you. All righty, what we will do, we will hear from Ms. Darnay if you have any final argument. Well, let me ask, do you have any additional witnesses? If not, we'll go to final argument and we'll hear from Ms. Giles.
¿Tiene algún testigo adicional? Y si no, pasaremos al argumento final. Escucharemos a la señora Stout.
I do have one additional witness, and that is the daughter that Ms. Chesmudis just referred to, Andrea Fernandez Chesmudis. You may
Okay.
unmute yourself.
Tengo una testigo adicional y es la hija de la señora Chesmudis, que es la señora Andrea Fernández.
Okay. Does she require interpretation as well?
No, I don't.
Okay, well, let's do it this way because the appellant does, even though we will be conversing in English, we will allow the interpreter the time to repeat everything in Spanish. So, ma'am, give us your name, then raise your right hand to be sworn.
Denos su nombre y levante su mano derecha para que le hagan juramentación.
The other right hand.
Oh, my bad. Andrea Fernandez Chesmudis.
Do you swear or affirm the testimony you give today be the truth to help you God?
I do.
¿Jura que el testimonio que va a dar el día de hoy va a ser la verdad? Sí.
Okay, please proceed.
Por favor.
Yes. So regarding
No,
the
Andrea?
the lawyer has to ask you questions.
Andrea, how old are you?
Andrea,
20.
do you mind just can I interpret what the attorney is saying and
Yes.
then
Everything that's spoken in English, we need interpreted.
Yes, no, I was just asking if she can wait until I interpret what the
okay.
attorney is saying.
Okay.
¿Cuál es tu edad, Andrea?
23.
23.
What's your highest level of education?
¿Cuál es tu nivel de educación más alto?
A bachelor's degree?
Mi licenciatura o mi bachillerato.
In what?
¿En qué?
In accounting business.
En negocios de contabilidad.
Has your mother, Lucero, traditionally relied upon you to interpret things for her?
¿Tu madre Lucero tradicionalmente ha confiado en ti para que le interpretes cosas?
Yes.
Sí.
Did you look at and interpret the violation notice in order to correct for her?
¿Tú observaste e interpretaste la notificación de infracción para corregirla?
Yes.
Sí.
Did you read it line by line to her?
¿La leíste línea por línea para ella?
No, I read the violation and then just gave her a brief summary.
No, leí la violación y le di un resumen breve.
That's the end of my questions.
Ese es el final de mis preguntas.
No cross.
Okay. All right, thank you very much. Are there any additional questions from the board itself? If not,
Yes, Mr. Chairman, I have,
yes.
sorry, I'm sorry, for the interpreter, go ahead, please.
¿Hay alguna pregunta adicional de parte de la Junta?
Yes, Mr. Chairman, I have some questions of Andrea Chesmudis.
Sí, tengo algunas preguntas para la señora Andrea Chesmudes.
Ms. Chesmudis, when you read the violation notice, did you see the language saying an appeal had to be taken in 30 days?
Señora Fernández, cuando usted leyó la carta, ¿vio que indicaba que una apelación tenía que darse dentro de los 30 días?
Yes.
Sí.
And did you inform your mother that the appeal had to be filed in 30 days?
¿Le informaste a tu madre que la apelación debería presentarse dentro de los 30 días?
Yes.
Sí.
And when the 30-day date arrived, did you notify your mother that you were at the deadline?
Y cuando llegaron los 30 días, la fecha límite, ¿le avisó a su madre que estaba ya en la fecha límite?
No.
No.
Thank you very much.
Muchas gracias.
Okay, thank you very much. Ms. Darty, if you have any closing argument, we will hear that now, then we'll hear from Ms. Skiles of the city.
Señora Darty, si tiene usted algún argumento de conclusión o cerrado de la discusión, le escucharemos ahora y luego escucharemos a la señora Kylie Silver.
To establish the right to relief non-pro-tunc, generally, it's most important that an appellant show that either there was non-negligent circumstances or a breakdown in the administrative system.
Para poder demostrar que hubo una intención no protónica, lo más importante es que un impulsor demuestre que hubo circunstancias no negligentes o que no se enfrentó contra el sistema.
In these circumstances, I submit to the board that there were non-negligent circumstances.
Cualquier circunstancia que yo presento o considero presentarle a la Junta son de circunstancias de no negligencia.
Ms. Chesmudis, whether that's the best or way to proceed or not, relied upon her daughter, who is only in her early 20s, to explain what she needed to do.
La señora Chesmudes, si fue la mejor manera de proceder o no, ella confió en su hija, que apenas tenía 20 y pocos años, a que le explicara lo que tenía que hacer.
Yes, she did know that there was the appeal date on March 27th, 2025, but she did approach, as she adopted the testimony, an expediter who promised her he could take care of this appeal.
I'm sorry, you cut out. Ma'am, can you hear me?
Yes, ma'am. I'm sorry. I'll
I'm so
repeat.
sorry, you cut out for me. Do you mind saying that again, ma'am?
Sure.
Thank you.
Yes, she did know about the appeal deadline of March 27th, 2025, but she did approach an expediter, Mr. Matos, who promised her he could take care of it, meaning appeal it.
Sí, ella estaba al tanto de que la fecha era el marzo 27 de 2025, pero ella contactó al señor Matos, quien le prometió que podía encargarse de ello, significando que iba a tratar de hacer la apelación.
Yet, even though she had that promise, she still made inquiries by approaching city council member.
Pero a pesar de que ella tenía esa promesa, hizo averiguaciones contactando a un concejal.
With the assistance of her daughter, she tried to get further clarity of the situation. And when she finally understood that she still had to take action, she did take action. I would submit that she was diligent in her efforts.
Con la asistencia de su hija, ella trató de aclarar la situación y cuando finalmente comprendió que aún debía actuar, lo hizo. Diría que actuó con deliberación y diligencia.
And
Thank you.
I believe that's all. Thank you.
Okay, Ms. Skiles?
Yes. Amy Skiles, once again, for the city.
Amy Skiles para la ciudad.
So it's the city's position that there is neither a non-negligent reason for the late appeal or a breakdown in the administrative process.
Es de parte de la ciudad indicar que no hay una apelación de no negligencia para este proceso.
Appellant's counsel admits that the appellant received the violation in late February 2025.
El abogado de la apelante admite que el apelante recibió la notificación a finales de febrero del 2025.
If I may be permitted to share my screen.
Si se me permite compartir la pantalla.
So on the notice provided by the city, on the last page, there is here a number to call for Spanish speakers.
En la notificación enviada, si te vas a la última página, hay una notificación que es para que llames a un número telefónico para las personas que son hispanohablantes.
So the appellant could have called this number and gotten the information from LNI about how to file an appeal.
El apelante hubiera podido llamar a este número y conseguir informaciones de LNI de cómo poder proceder con esta apelación.
Instead, the appellant relied on an expediter and then further reaching out to city council.
En lugar de eso, el apelante decidió respaldarse en un expedidor y luego llamar al ayuntamiento.
Mistakenly placing reliance on the expediter or city council is not a non-negligent reason for filing the appeal. In fact, the city would say that it was because of the appellant's negligence that the appeal was filed late.
Que ella haya contactado con el ayuntamiento no es un motivo no negligente para interponer el recurso. Al contrario, diríamos que ella puso el recurso o la apelación porque hubo una negligencia.
It is the appellant's responsibility to make sure that the appeal was filed. So it was the appellant's responsibility to follow up with the expediter to make sure that that appeal was filed by the 30-day deadline.
Es la responsabilidad del apelante asegurar que la apelación se presente. Por lo tanto, era la responsabilidad del apelante hacer seguimiento con el expedidor para asegurar que la apelación se presentara dentro del plazo de los 30 días.
So while the appellant may have been taking action, it's the city's position that at no point did the appellant take the appropriate action by reaching out directly to LNI or filing an appeal. And for those reasons, we don't believe the standard for nunc-pro-tunc relief have been met.
Mientras o si bien el apelante pudo haber tomado medidas, la postura de la ciudad es que en ningún momento tomó la medida adecuada contactando directamente a LI ni presentando una apelación. Por estas razones no creemos que se haya cumplido el estándar para la reparación y protección.
That's the end of my argument.
Ese es el final de mi argumento.
We will now poll the board regarding HA 2025-002638.
Vamos a llamar ahora a la Junta con respecto al HA 2025-002638. You said what the last two?
38.
38.
3430 North Bodine Street, Lucero, Chesmudes.
3432 Main Street para la señora Lucero Chesmudes.
Now, each board member will cast its vote.
Cada miembro va a dar su voto.
Request for non-pro-tunc relief, denied.
Relief denied.
Wait, wait. Interpreter?
Oh, I did. I said denegado.
Relief denied.
Alivio denegado.
Relief denied.
Alivio denegado.
Relief denied.
Alivio denegado.
Relief denied.
Alivio denegado.
Okay, thank you very much. The unanimous vote is released, denied, so this appeal will be dismissed. Ms. Darty, of course, you may appeal our decision to the Court of Common Pleas. Thank you very much for your participation.
Thank you very much, members of the board.
Okay.
De manera unánime, los votantes han denegado, así que por supuesto usted puede apelar la decisión ante el secretario de actas.
Okay, thank you. Interpreter, I think we're done unless do we have another matter? Okay, we're done for today.
Okay, thank you. Have a good day.
Okay. All right, what's our next matter?
If we could recall item number 13 on the list, that was hearing appeal ending 2355 for 1002 West York Street, New York, Famous Euros Incorporated. Michael McElhenney Esquire is the attorney.
Okay, Mr. McElhenney and Ms. Giles, any progress?
So there was some confusion in the appeal that was filed. This may be resolved. I just need to clarify with my client. So if we could request a joint continuance today,
Okay.
it may be resolved.
Mr. McElhenney, do you confirm?
I concur. That'd be excellent.
Okay, all righty, so we'll note this matter as continued.
Thank you.
Thank you.
Thank you for your time.
Okay.
Bring your attention, sir, to items 34 and 35. Item 34 is hearing appeal ending 2645 for 1539 North Sixth Street. Ophir Comeranian, doing business as Prestige Design and Construction LLC.
Okay,
Item 35 is hearing appeal ending 2709 1557 North Sixth Street. Appellant Ophir Comeranian, doing business as Prestige Design and Construction LLC.
okay, who's representing the city?
Thank you. May it please the board, Leonard F. Reuter, Reuter, for the city of Philadelphia.
Good afternoon, Mr. Reuter. Okay, who's representing the appellant? Ophir Comerian, or DBA Prestige Design and Construction LLC. Anyone present?
I believe Mr. Comerian is present. However, the city had previously raised an issue of whether of who the actual appellant is in the relationship to the property owner. But
Okay, is there a standing issue potentially?
it's whether they need counsel.
Okay.
But I will say that we can go ahead. I think he's
Okay.
here.
Mr. Comerian, please raise your right hand to be sworn. Do you swear or affirm the testimony you give today be the truth to help you God?
Yes.
Okay, sir, before we begin, what is your relationship to these two properties noted in the appeal and Prestige Design and Construction?
I'm the owner.
You're the owner. Were the violations written to you personally or to the company's name?
To the company. No, to me.
Okay.
No.
It's the violation's kind of written about, it says Ophir Comerian and then in parentheses, Prestige Design. So I just wanted clarification for that.
Okay, so
In this
that,
instance, wait. This instance, are you concerned that he needs to be represented by legal counsel?
If he's right, again, he did receive, there was a violation issued in his name. If he's representing himself, if he can just explain what his relationship is to Prestige Design, which is an LLC, and he's.
Well, he represented a moment ago that he's the owner of Prestige LLC. And
I'm the
so-
owner.
Pardon me?
What Can I say something? There is
Yes. Yes.
So on the violation, it say Ophir Comerian Prestige Design on Girard. But this is how the contractor name is formed. So it's not on me personally, it's on my contractor license.
Okay,
That's-
I'm doing your contractor's license. Okay. So that means that you need legal counsel to represent you in these hearings then, unless I'm getting a different understanding from the city.
Again, I mean, the city's position here, this is, both of these, they're actually, it's not entirely clear whether they're related. They're right near each other, but they're two separate footway notices for not providing proper sidewalk and clearance during construction. I will say the appeals are about 10 days late. The city's position, again, is that they are on their face late. We don't believe that the city's going to suffer any prejudice if the late appeal is allowed to proceed. So.
But you're arguing a different point. The issue that I'm still stuck on is whether or not he needs legal counsel.
Well, because the violation was issued to him in his individual name, we think that he can bring the appeal, but we'll defer to the board on that.
His name is on the violation notice, therefore he can represent himself.
Okay. Okay, all right. Okay, sir, in this instance, we're gonna move forward to hear your request to submit a late appeal. The violation notice was written on May 29th, 25. You submitted your appeal July 9th, 2025 for 1539 North Sixth Street, and you submitted your appeal on July 11th for 1557 North Sixth Street. Your reasoning for submitting a late appeal?
Yes, we didn't receive it. And I know why we didn't receive it.
Why?
Because we registered the business at 1442 North 7th Street /office. And when they send it, they didn't send it to the office because we got 3 other residential. So we physically didn't get the mail. It could be mixed up with other neighbors, with other tenants.
Okay, the address used on the violation notice is what? Someone just, Mr. Reuter, do you have that handy?
Yes, it's 1442 North 7th Street. That is the address that the site violation was sent to.
And sir, is that not your mailing address?
Yes and no. It is the mailing address, but it's not linked to saying office because the building structure is office, unit 1, unit 2, and unit 3. And that's how we
Okay.
register it on Eclipse also. So we never received the violation and received the latest notice that we have in a bill that we wasn't aware of.
So your company's name was on the mail. Your argument is that because it did not say office, you did not receive it. Is that the case?
It could go to any of other units.
Okay. Mr. Reuter, any response?
Yeah, I mean, I think he's saying that in the building's divided up into separate units. Their unit is literally office unit, and that the mail wasn't provided to that unit. Again, the city's position here, again, because it's barely late by 10 or 11, 10, 1, and then I think 11 on the other violation, but also have to verify. He did not initially say in the appeal about the office address, and I think he just indicated that that was listed specifically on the
Eclipse
record with L&I, so I have to double check that because we didn't have that information previously.
Yeah, we're having problems hearing you, Mr. Reuter.
I'm sorry, yeah, he didn't previously state that was the specific reason why they didn't list it, so I have to verify that. If you give me a moment.
As you're looking through that, we took a quick look at the appeal. Sir, you didn't indicate that office was part of the address. You just indicated the address.
It's indicated what
It
unit
didn't
is.
say office. It just says the address. It doesn't reference office at all.
Okay,
You
it's
filed a petition for late appeal, and in that petition, where you're supposed to give your mailing address, you said 1442 North 7th Street, but then didn't say after that office. And in your petition to the board for a hearing, you also listed your address as 1442 North 7th Street. However, you didn't say office. So if you were concerned that, or you said the city should have known to send it to office, why is it that when you filed your appeals, you didn't say office on your appeals?
why they didn't write it on office. I'm not sure. I'm not sure why that's happened. But what I know, originally, you guys didn't send it to me, so I didn't receive it.
Okay,
It's pretty.
thank you.
I'm
Mr.
appealing-
Rowley, I'm sorry. I apologize for cutting you off, sir. Anything else you want to add?
So
We-
again,
No, I'm asking him.
oh, I'm sorry.
Sir, anything else you want to add before we hear from Mr. Reuter?
Me?
No?
No.
Yes, okay.
So
Mr. Reuter?
Know about.
So the city can verify, now that we've been given the specific argument, that the OPA account for 1442 North 7th Street, which is Prestige Design on 7th Street LLC, 1442 North 7th Street, does in fact specifically list Prestige Design on 7th Street LLC, 1442 North 7th Street office as the unit.
Okay.
So the violation was just to 1442 North 7th Street. I leave it to the board whether that means it would not have been received. I can't verify who is in the other units, but it does appear there's 3 or 4 units in that building.
It's
Okay.
three other.
Three other
So-
units. But the issue though is in terms of whether or not the appellant himself used that designation office. That's part of the issue here.
Mm-mm.
Okay. Anyone else have any questions for the appellant or Mr. Roder? Any other comments from anyone before we proceed to call the vote? Mr. Marion, do you have any final comment you'd like to make? No? Okay, Mr. Roder, any final argument you'd like to make?
No, the city will just defer to the board on this one.
Okay, thank
On
you.
both of them. I think it's an identical issue on both of them.
Okay, we will poll the board. We'll vote on each one separately. HA 2025-002645, 1539 North Sixth Street. Ophir Kamarian doing business as Prestige Design and Construction LLC. Request for non-pro tunc relief denied.
Request granted. Relief denied.
Relief granted.
Relief granted.
Okay, in that instance, the vote is 3-2. So you won the request. We will schedule an appeal for that location at 1539 North Sixth Street. Okay, let's move on to HA 2025-002709, 1557 North Sixth Street. Ophir Kamarian doing business as Prestige Design and Construction LLC. Request for non-pro tunc relief denied.
Request granted. Relief denied.
Request granted.
Request granted.
Okay, the vote is 3-2 in terms of granting relief requested. So in that instance, sir, you will be scheduled a regular appeal hearing. Have a good afternoon.
Thank you so much. Have a good day, guys.
Okay, what's our next matter?
Calling your attention to item 36 on today's list. That's hearing appeal ending 2702. That's for 2015 South Opal Street. Cheryl Brown is the appellant.
Okay, who's representing the city?
Good afternoon, Kristen Patchell for the city.
Okay, Cheryl Brown. Cheryl Brown, are you present? 2015 South Opal Street. Anyone present representing the interests of 2015 South Opal Street? Anyone present?
Sir, in this matter, the appellant's listed 2015 South Opal Street in the appeal. Notice of this hearing was sent to that address on 7/22/25.
Thank you. There's been no response. What is your pleasure?
The city would ask for a dismissal due to non-appearance.
Okay, what time do we have?
3:13 p.m.
3:13 p.m. Thank you very much. We will poll the board on HA 2025-002702, 2015 South Opal Street, Cheryl Brown. Matters dismissed for failure to appear.
Dismiss for failure to appeal. Dismiss for failure to appear.
Dismissed for failure to appear.
Dismiss for failure to appear.
Thank you. Does that complete our non-pro tunc list?
Yes, sir, it does.
Okay, we will take a short executive session and return promptly in about 3:20. Thank you. Good. Good afternoon. We've had a long session earlier prior to this, dealing with non-pro tunc matters. This is our regular list. One of the challenges we will have though is that we have a hard stop at 4:30. So what we will do is hear matters, and at 4:20 or 4:25, depending on where we are in witnesses, we will break and we'll certainly reschedule to bring everyone back. But we doubt that we will be able to complete all the cases that are listed for today before 4:30. I know this creates some challenges for both sides, and so we will apologize in advance. But unfortunately, our hands are tied. Okay, so we'll ask Mr. Moto to read in, well, let me hear from the city. Is there a list of preliminary matters from the city regarding our regular list that we need to put on the record?
Sure, just one that there's no controversy about. I wasn't clear whether you already took it off the list, but it was originally number 7 on the list, HA 2020-001673 for 2700 South Broad, Friends of Marconi Plaza. That matter is, and actually my co-counsel for the other case was representing with Mr. Paquetto, the appellant in that case. All parties agree that that appeal can be just simply marked moot.
Moot, okay, thank you. All righty. Now, we have cases, any other matters on this list that require any preliminary announcements?
Just for the record, so we put it out there, the other case that we have, that was the add-on for today, 1300 Walnut, it is the city's position that that case should also be marked moot, but I understand there's going to be a lot of argument about that, so I just
Okay.
want to put that out there. We'll just probably do that when it gets called.
Okay, we'll call that one last because it will require a bit of complexity to unravel. Okay, all righty. So, Mr. Moto, would you call in order then?
Ms. Laughlin has her hand raised, I believe.
Ms. Laughlin? Oh,
Yes,
my apologies.
I do.
Yes.
That's okay. Good afternoon, Board. Roses Lachlan for the city. The matters listed today, 2, 3, 4, 5, and 6. Those matters were administratively continued on September.
Oh, you cut out. We can't hear you.
Can you
can't
hear?
you. Yeah, I can hear you now. Well, let me do this. Let me read it into the record. I believe I heard what you said for the most part. HA 2024-001286, 2501 Margaret Street, Advanced Resins and Chemicals LLC. The request is to continue it. And I guess the question for you, this is the 5th listing.
We have already administratively continued.
You have?
Yes.
Okay. So we will continue, that matter has already been continued for the record. The following will also reference 2501 Market Street. That's 01289, 02727, 4549, and 4550, all are being continued. Thank you. Anyone else? No? Okay. Mr. Moto, please call the next matter.
Yes, sir. That brings us to item 1 on today's list. That will be hearing appeal ending 1051 for the property 4272 Viola Street, Helen Houston, doing business as Lavinia Houston.
Okay, do we have Helen Houston present? Ma'am, you're muted. Who's representing the city on this matter?
I am Roses Lachlan.
Okay, all righty. Mrs. Houston, would you unmute yourself, please? Okay, Helen Houston, would you raise your right hand to be sworn? Do you swear or affirm the testimony you give today be the truth so help you God?
Yes.
All right, thank you very much. Okay, Ms. Lachlan, where are we today? What are we doing?
Yes, so first in this matter, there's a preliminary issue. The reason that this case has been continued so many times is that the city had raised a standing issue, but this is a tangled title situation, and so the city is willing to waive its standing issue in order for this matter to proceed today.
Okay, Ms. Houston, I take it you have not been able to get the deed transferred into your name yet?
I haven't been able to do that.
Okay, have you secured the services of an attorney to make that happen?
No, I didn't Because what happened is somebody's name appeared on the deed that shouldn't have been on there. And it wasn't anything an attorney could do. And I did go to the law center, and they said they don't get involved with cases like mine with the city.
Okay, so you have some more work to do, and you may need to contact the district attorney's office or something in order to have some additional legal action taken. But I just want to seek counsel myself.
I don't, first of all, I don't even understand how this is even happening when I've been appointed the executive of the.
Wait, ma'am, the being point is, yes, okay. The water department has agreed to proceed. Just for a moment, I just want to get some reaction from my counsel.
The issue of standing is waivable.
Okay, thank you. So we're going to proceed today, okay? And so what we will have, Ms. Lachlan, you,
please.
Okay.
Let me throw myself on your mercy.
Okay, Ms. Lachlan, please, you have a witness for today, Ms. Lachlan?
I do. The city intends to call Miss Odessa Walker as the witness.
Okay. Is Ms. Walker present?
Yes, I am. Can you hear me?
Yes, I can hear you now.
Okay.
Yes, raise your right hand to be sworn, please. Do you swear affirm the testimony you give today be the truth so help you God?
Yes.
All right, thank you very much. You place your hand down. Okay, Ms. Lachlan, let's begin.
Okay, so this matter is related to a notice of defect that was issued to the property at 4272 Viola Street on February 21, 2024. The water has already been shut off at the Farrell, and the property was vacant at the time of the NOD, and it's still vacant now. So the city has re-inspected and found no repairs to be made. And so the city affirms its notice of defect. I have a few questions for Ms. Walker, if she's prepared.
Yes, please call your witness.
Ms. Walker, could you please state your name and your current title?
Odessa Walker Frazier. I'm a Water Customer Field Services Supervisor.
And how long have you been employed with the water department?
30 years.
And are you familiar with the record for the property at 4272 Viola Street?
Yes.
With the board's permission, am I able to share my screen?
Yes, please.
The exhibit. Are you able to see the notice of defect?
Yes.
On screen. And can you please explain why this defect was issued to this property?
We got a radio call that there was a, let me see. Just reading. Yeah, we got a radio call that it was a leak in a vacant property. So when the inspector did his inspection, he found that the leak in the vacant property was at 4272 Viola Street. And he wasn't able to shut it off, so he had to send it to distribution so that they can shut it off in the street, which is at the Furrow.
And how does PWD do that test for the service leak?
Well, we have a metal rod that they put on down in the curb box on the curb stop, and they listen with the aquaphone. They listen for leaks, so they listened at that property.
And I'm gonna move to the City Works report now. Have you had a chance to review the City Works report as well?
Yes.
And does this report indicate that that multiple re-inspections have been made at this property.
Yes,
And what is the result of those re-inspections?
that they found that there were no repairs made to the leak on the water service and that it still remains off.
Okay. Thank you. I have a few questions regarding the records themselves. So you were not the inspector who actually performed the exam at this property, is that correct?
Correct.
But you are able to review the records.
Yes,
And these are the normal records as kept in PWD's ordinary course of business.
yes,
And these are prepared by the inspectors who do go to the property.
correct.
And so the city asked that this exhibit be moved onto the record.
So moved. Okay. Any additional questions of this witness?
I don't have any further questions at this time.
Okay, Ms. Houston?
I have
you-
questions.
At this time, do you have any questions of Ms. Walker?
I certainly do.
Okay,
Ms. Walker, I contacted the water department. Water company says they don't have a record of ever
okay, Ms. Houston?
being out
Ms.
at that
Houston?
property.
Ms. Houston?
Yes,
What we need you to do is ask a question, not make a statement. You can make a statement later, but I need you to ask a question if you have a question, okay?
okay. So, Ms. Walker, what area of the city do you live in?
That's not relevant to this hearing. Okay, so she does not reside in the property in question, and so she doesn't have
I
any
know she
personal
doesn't
contact.
reside in the property in question. I'm just asking to see if she's familiar with that particular area.
Well, that's a different question, not where she lives. You can ask her if she's familiar with that area.
Are you familiar with that area?
Are you saying West Philly?
That particular area of West Philadelphia.
Yes, I know West Philly.
Anything else, Ms. Houston?
Exactly, when you got these reports that no repairs had been made, why wasn't the property owner notified of any further discussion?
Well, the property owner is notified when the repairs are not made. We send a final notice. If the usually if the water is not turned off, we'll leave an intent to shut off. But since the water was already turned off, they'll just send a final, which goes to whatever address you have listed for the water bill to go to. That's the address that the send final will go to. So when the inspector does the inspection, they see that no repairs are made, then they'll come back in, that goes to the office staff, and they'll send out a send final notice, letting you know that this is your final notice.
Well, no notice came.
Okay, that's not a question.
Okay, okay.
Okay, thank you. All right, Ms. Loughlin, do you have any additional witnesses?
No, I do not.
Okay. All right, Ms. Houston, is your opportunity to share with us your understanding of what's going on at this address.
Well, yeah, there's a couple discrepancies that I have, and I like to share my screen with you if I can. I like to bring up a picture.
Okay.
I did submit that picture.
You may share your screen if you want to share your screen, please do.
Okay, first of all, I gotta get in here and wait a minute. Wait.
Are you having any success?
Okay, wait, I'm trying to get to the share the screen. Yeah. See that? That's the water company in front of 4272 Viola Street.
Okay,
And my suggestion is that with all of that heavy equipment, that digging, that there is the possibility, reasonably thinking, that the water company themselves could have cracked whatever was leaking over there.
okay. Did you have a plumber confirm any of that or any other
We
expert?
didn't know anything about it. I didn't get the notice that there was an issue until about 15 days after the grace period, of which would have allowed me to have the item fixed on my own.
Okay, now
So
that
I don't
we,
even think it's a valid violation. I don't even think we should have continued it from the first.
okay, the fact that you received notice, did you take any action to have a plumber confirm for you whether or not the water
15
line
days
was-
after the grace period.
Ma'am, I didn't ask you the date. I asked you, did you take any action? Did you call a plumber? You have anybody do an evaluation for you?
No, because they said they did it. The city said they did it.
Okay, we'll have to confirm that with the city. Ms. Lachlan, did the water department make a repair on that location?
No, no repairs have been made to the water service leak at this property.
There's a new patch in the street.
Excuse me, can I say something?
No, wait. Ms. Lachlan, Ms. Walker is your witness. At the moment, we're hearing from Ms. Houston's presentation. After she's
sorry.
finished, if you want to recall your witness, you may do that. So I'm not gonna have a free-for-all. Ms. Houston's, anything else you want to add before we go back to the city?
I'll wait my turn.
No, this is your turn.
Okay. And like I said, I went, after I was trying to get a hold of the water commissioner and found out the city of Philadelphia doesn't have a water commissioner anymore, I did get to the water department. And that's when I was told they don't have a record of ever being out to that property for a violation.
Okay, so your position is that the violation was issued by mistake or an error?
Yeah, I think it was issued by mistake. It's happened before. I mean, we were written up for a violation, and it just so happens we were at that property the very day the violation was supposed to have occurred with a licensed contractor who could verify in writing, and he did, that there wasn't anything leaking at that property.
What date was that?
That was about over 10 years ago.
Oh, okay. All right, thank you. Okay.
Yeah.
Anything else you want to add?
So it
that would
seems
help
like
us?
it's a cycle, this comes around. Okay, we'll hit this property up again this time, and
Okay.
I don't know what's
Anything
going
else you
on
want?
here.
Any additional factual information you want to put on the record?
Well, actually, yeah, the only other facts is that financially, it would be an extreme hardship for me based upon Social Security has shut me off. I'm one of the ones that got caught up in all of this, throwing this Doge. I'm thrown off as of July. So I don't have a personal income as of right now.
Okay.
So it would be an extreme hardship for me if this was attributed to me. And the other side of it is I can't get a definitive answer on what the cost would have been.
Okay. I'm not sure that anyone has come up with a cost. The cost would be from your private plumber to tell you what the repair would be. That's where the cost number would come from. If the city does the repair, they would then tell you what it is charging, but I don't believe the city has done a repair. Okay, all right.
So how did they shut water off?
I'm not sure I
Water's
understand what,
There's been no water at that property since, and I left there in 1971.
the city's arguing is that there's a leak, so they had to turn it off because of the leak. That's what the city's position is.
There's no pipes in there. There's no water. There's no utilities whatsoever. The house is basically a
Yeah,
shell.
no, the city's argument is that the water supply line was leaking in the street. That's why it was shut off. Okay, let's
And
hear.
the water
it from-
company, this is what the water company said to me when they were putting in new meters. Behind the
When
fact
was
that
this?
this property
When-
has been empty so long, everything would have to be replaced as new.
Okay. All right, Ms. Laughlin, do you want to recall your witness? Do you have any information you want to share?
I do have an additional question for Ms. Walker. Ms. Walker, are you able to address the patch in the street that has appeared since this issue, since the notice of defect was issued?
I haven't seen a patch, but I'm not, if it is a patch in the street, it's probably when the water department digs up in the street, they have to refer it back to the street department so that they can put the street back the way it needs to be, like bring it fully up. So it might have went to the streets department and they came out and repaired the street. So that might be why she see a patch in the street now.
Why would the street have been dug up in this case?
To turn her water off at the furrow.
And that requires digging up the street in order to access the feral.
Correct.
Thank you. I don't have any further questions.
Okay, before we leave this, Ms. Walker, this image that's on the screen now, are you suggesting that that private contractor's truck and that heavy equipment was used just to terminate a furrow, to shut off service to one property? That doesn't appear to be that. It appears to be something more
No,
extensive.
if you look at that picture is from July of 2020. She received a notice of defect in February of 2024, and that's not a city truck. A city truck would have a water department logo on it.
It's
So that's
going
not.
down a little further.
Okay, wait a minute, Ms. Houston, you can't speak while someone else is speaking, okay?
Yeah, that's not a water department truck.
Okay, so does your record have any evidence, do you have any records of extensive water department activity on Viola Street in terms of repairing main supply lines or waste lines?
You're asking me, do I have any information?
Yes.
No, I don't have any information of them making repairs.
Okay, all right, thank you. Anything else, Ms. Laughlin?
No, I have nothing further. Thank you.
Anyone else have any questions?
Yes, I have a question, Mr. Chairman,
Yes.
of Ms. Walker. Ms. Walker, please correct me if I'm wrong, but I believe I heard you say that a call came in about a leak in the basement of the vacant property at 4272 Viola. Was that your testimony?
No, that's not what I said.
You said you got a radio call, did you not?
Yes, I said, yeah, we received a radio call. I didn't say about a leak in the basement of 4272 Viola.
Okay, can you correct me then? What was your testimony?
I said we got a leak we got a call in reference to a leak.
In.
A leak, and where was the leak evidence?
Well, they found the leak evidence the address came in at the 4272. That's where they said it was a leak. When the inspector got there, he found that there was a leak at 4272 Viola after he did his inspection.
And was the leak on the surface?
I have to read the, 1 minute.
Ms. Walker, adjust your screen a bit because all we see is the top of your head.
Oh, I'm sorry. Can you see me now? I can't
Just
see myself on here.
adjust it a little bit more. That'll be helpful. Yeah, perfect. Okay,
Right
thank you.
there?
Yep.
Okay. Well, the inspector didn't say he said he found the leak outside. He said he found the leak. He just said I'm gonna just read his comments. Found leak on the defective water service line at 4272 property vacant, shut off at curb stop, leak remained and worsened, good sound on curb stop, found on, no sound on curb stops, found on at 70-74, refer to distribution due to winter schedule.
Okay.
So that was,
Okay, all right, you don't have to read all of the comments. I appreciate you taking the time. Thank you. Obviously I misunderstood your testimony. Thank you.
Okay.
okay.
I didn't misunderstand it. She said
Oh,
in.
no, Ms. Houston, you can't speak out of turn, okay? This is not a conversation. This is formal testimony. Okay, so we do have another question from a board member. Yes.
Did I hear you say, Ms. Houston, that this property has been vacant since 1971?
That's correct. That's when I
Thank
left.
you.
Okay, anyone else have a question? Okay, if no one else has a question, Ms. Houston, we will invite you to give any final comments that would help us make a decision in this matter, after which we will hear from Ms. Laughlin with final argument, okay?
Yes.
So
Well,
any comments, any information or comments you'd like to make that will help us make a decision?
I think if there was a leak at that property, when the water department, and that is the water department, was there working, because I took that picture. I happened to be there that day, and I said, let me take this picture because I got a feeling one day I'm going to need it. And they were laying pipe all the way through the whole block of Viola Street.
And this was in 2020, correct?
That's correct. And with all of that humping, bumping, knocking, and jiggling, it's reasonable they could have caused a hairline crack. Okay, that leaked over time. And it wasn't something that was negligent on the property owner's part. But like
No, this isn't, keep in mind, we are not holding anybody as being negligent. The issue here is whether or not
I think they caused that.
I'm not finished, ma'am.
Okay.
You're speaking before I get finished. The issue is whether or not the leak is actual and whether the city correctly identified the leak at that address and wrote a violation. And when that occurs, the property owner is responsible for making the repair. If the property owner believes that some other entity is responsible for the damage, then they can take legal action against that other entity, such as the water department. There's a claims department you can go through if you believe that they damaged your property. But the issue here is strictly whether or not the water department identified a leak at that location and whether or not the violation was correctly written. Okay, ma'am, would you mind taking down the photo that you're sharing, just so that we can clear up the screen? Okay, Ms. Laughlin, do you, Ms. Houston, is that your final comment before we move on to Ms. Laughlin?
No, I really don't think there was anything at that property. I really don't. It seemed very sketchy that one department doesn't know what the other is saying. That the water company themselves said, we don't have a record of ever being out at that property for a violation.
Okay, thank you. Ms. Laughlin?
Yes. The city asked the board to affirm the notice of defect in this case. The city has provided its records of going to the property at 4272 Viola Street, both the initial notice of defect, which indicated the leak of water supply, and the methods by which they located that leak, and records of multiple re-inspections that further confirmed the leak, that the leak had been there. And so absent Ms. Houston providing plumbing records or any indication that of proof that there was no leak here, we believe that the city's notice of defect stands.
Okay, thank you very much.
And wait a minute, do I get a rebuttal with that one?
Well, this final argument, so there's no really a need for rebuttal unless you believe that there's some factual misstatements.
Well, first of all, that notice says that you have 10 days to make that repair. If the city is going out there and re-inspecting and find that the repair isn't made, how come the city didn't make the repair?
Well, that's not a question for this hearing because the city,
But I mean,
ma'am, listen to
far.
me. The city is not required to make the repair in this
But
case.
it
so-
notice says they will make the repair.
Okay, that's it. Okay, all right. We're going to move to poll the board and vote on this matter. Thank you very much. Regarding HA 2024-001051, 4272 Viola Street, Helen Houston, DBA Lavinia Houston, City affirmed.
City affirmed.
City affirmed.
City affirmed.
City affirmed.
Okay, Ms. Houston, the vote is unanimous, city affirmed, which means your appeal was not successful. Now, you may appeal our decision to the Court of Common Pleas. If you need information as to how to do that, check with the administrator's office and someone there will give you information that you need to appeal a decision of this board. Thank you very much, ma'am, for your participation today.
Thank you.
Okay, let's
Will I
proceed.
get a notice? Will I get a notice about
Yes,
that?
ma'am, you will get a decision letter in the mail.
Okay, thank you.
Okay, let's proceed. Let's continue to our next matter.
Yes, sir. Calling your attention to item number 8 on the list, hearing appeal ending 4234, 1300 Walnut Street, PMC Property Group, Michael Mattioni Esquire representing.
Okay, good afternoon.
Good afternoon.
We need counsel, please put your names on the record, please.
Michael Mattioni, appellant, representing the appellant PMC Property Group.
Thank you.
Thank you. May it please the board, Leonard F. Reuter, REUTER for the city of Philadelphia.
Okay, what I'd like to do, given the,
And one additional, Matthew Minsky on behalf of Woody's Bar.
okay,
the
so you're
intervener.
joining, okay, on the other side.
The posture's a little bit odd in this case, but we can explain.
Okay, all right, thank you. What I'd like to do, though, given the complexity of this matter, is that I'd like counsel to give a short opening statement to clarify the issues for us before we begin calling witnesses, et cetera. As you know, we do have a hard stop, so we just want to get some sense of what we're doing here before we start getting into the matter itself. So I'll invite Mr. Mattioni and then Mr. Reuter, and if you need support from the other counsel, you will do that. Okay, Mr. Mattioni?
Thank you, Mr. Chairman. Again, I'm Michael Mattioni, and I represent PMC Property Group. They're the property manager for the properties located at 1216-18 Walnut Street, owned by Midtown Associates, 201 South 13th Street, owned by Walnut Square Partners, and 135 to 45 South 13th Street, owned by Empire Building Partners, all of which are either directly adjacent to, across from, or one property removed from Woody's Bar at the southwest corner of 13th and Walnut Streets. PMC filed this appeal of the renewal of the special assembly occupancy license for Woody's, which is necessary for Woody's to offer social entertainment, including dancing, live and recorded music, and DJs. We provided exhibits to the board, including a CV and report from Graham Everhart of Metropolitan Acoustics, a sound and noise expert, and a CV and report from Russell Collins and KSG Security Group, their security and risk assessment experts, letters of opposition from 39 residents of the Walnut Square Apartments, some Google Maps, some photographs, some videos showing the operations at Woody's and conditions on 13th Street, memorandum of law, and some other L&I records. We have 6 witnesses to present: Tracy Mitchell, who is the manager of the 3 properties in question, Graham Everhart, the audiologist, Russell Collins, the security and risk assessment expert, Alex Hoffman and Jeff McEldowney, who are either current or former residents of the Walnut Square building, which is adjacent to Woody's, and Candace Schneeberger, who resides at 1334 Walnut Street, which is about 500 feet to the west of Woody's. Woody's is directly across Walnut Square is directly across the street from Woody's and is negatively impacted by the operations at Woody's. PMC appealed the renewal of the SAOL that allows Woody's to have social entertainment, including dancing, live music, and DJs. The renewal application should be denied or it should be revoked because of the failure of Woody's to properly notice the application for renewal of the SAOL. Section 97032A2 of the code requires that notice of the SAOL application be posted on all street frontages of the property for which the SAOL is sought. The SAOL notice was only posted on the 42-foot-long frontage on Walnut Street, not the 118-foot-long frontage on 13th Street. The city's exhibits confirm this. As a result, this appeal should be granted due to the failure of Woody's to properly post the notice of the application for renewal. In addition, PMC will present evidence that shows Woody's is operating in violation of the Philadelphia Noise Ordinance, in violation of the noise provisions of the SAOL ordinance, and the PLCB noise statute, and that Woody's operation creates excessive noise, traffic, litter, has hours of operation until 2 a.m. that are disruptive to neighbors, and will raise these concerns through the testimony of the immediate neighbors, warranting the granting of this appeal and revocation of the SAOL. Testimony will be presented that shows Woody's does not meet the operational requirements of Section 9703 3C3 of the code by creating a nuisance, warranting the granting of this appeal and revocation of the SAOL. Walnut Square is directly across the street from Woody's, and there is overwhelming opposition to renewal of the SAOL, as will be shown by the opposition letters and the testimony of Tracy Mitchell, Jeff McEldowney, a current resident, Alex Hoffman, a former resident of Walnut Square, and Candace Schneeberger, who resides at 1334 Walnut Street. And they will all testify regarding the excessive noise and behavior of the crowds created by Woody's, making it difficult to access Walnut Square, and the trash and vomit left behind by Woody's patrons. Videos and photos will also be used to show the conditions created by Woody's and how Woody's operation is a nuisance that should not be permitted to continue to operate. Candace Schneeberger will also testify as to her personal knowledge of conditions outside of Woody's and how she is adversely impacted by Woody's inside her home. Graham Everhart, the audiologist, will testify regarding the noise levels emanating from Woody's and how these noise levels exceed the ambient noise levels by more than 5 decibels when Woody's is in operation, in violation of the noise ordinance in Philadelphia, and how Woody's violates the SAOL noise ordinance and the PLCB noise statute, creating a nuisance. Russell Collins will testify regarding the operations of Woody's, which creates security concerns, and the nuisance Woody's creates with its operations and the safety issues that Woody's presents for the community in violation of the SAO ordinance, and how Woody's is not a proper location for a special assembly occupancy, taking into account the conditions at 13th and Walnut Streets in violation of Section 9703 2B 4C of the code. The testimony will show a failure of Woody's to meet the requirements of the SAO ordinance, and that Woody's is not a safe and proper place for a special assembly occupancy, as Woody's creates traffic problems, noise in excess of the levels permitted by the noise ordinance, safety issues, community concerns, which are directly to be looked at in the SAO ordinance, and raised by Woody's operations, making Woody's not a suitable location for the SAOL. And like I said, Mr. Chairman, I do have 6 witnesses that we will call when
Okay.
time permits.
All right, thank you. Okay, Mr. Rowder?
So the city's initial position is that even if everything that Mr. Matty and his client intends to prove can be demonstrated, it's moot now because the license renewal that they are challenging is for a license that expired August 31st of 2025. And in fact, the licensee, Woody's or Wood Bar, I think is their formal name, has in fact submitted an application for the renewal for the next period, which would be, begin as soon as if the license is granted. So currently that application is under review. I believe most currently they've been asked to provide photos of the current posting of the application. Once the city verifies that the application or the intent to apply for the renewal has been posted properly, then the city Department of Licenses and Inspections will refer that application to the police department. Police department takes into consideration all of the things that Mr. Mattioni and his clients are talking about. The posting also provides an opportunity for members of the public, such as Mr. Mattioni's clients or the tenants of his clients, to come in, to reach out to the police department, reach out to L&I, and everything that he wants to present today or the next time we're able to come back, if assuming this is bifurcated, they can present everything the 800,000 pages that they submitted. They can provide all of that to the police and to L&I and tell L&I or the police, don't recommend renewal, don't renew this license. But the license that was appealed is expired. It's moot, it's done. And so, I understand at the time the appeal was filed, it wasn't necessarily moot, but because the license in question on its face, it's actually attached to the appeal, expires August 31st of 2025, and understanding the huge caseload that the board has and the amount of time it takes the board to hear cases, that the initial applicant, the appellant, should have specifically requested an expedited appeal, knowing that in the best of circumstances, this case, I think originally was going to be heard in July, assuming, as I think everybody would, that regardless of what the decision is, there would be an ensuing appeal. This case was always going to be moot because it wasn't heard fast enough. So the reality is that we are here, the only thing before this board is whether or not the renewal of the license for the SAOL that was issued to Woody's was validly renewed, and it's the city's position that that question is moot. If they want to say that we were wrong to renew it, we shouldn't have renewed it, whatever, that they can say that. And again, the city believes they're wrong. The city believes we followed all of the process that was required, but they can make all of those arguments now. There is a new permit application currently out there. The city has specifically requested that Woody's present proof, as they were required to, that the property has been properly posted with the application, and the process starts anew. So because what's going to happen is, if this appeal goes forward, the renewal, a decision is going to be made on that renewal, and whichever side gets what they want in that renewal application, the other side's going to take an appeal from that, and we're going to be back right here on the same exact thing.
Okay.
On a new license, and
What-
that's just a waste of resources.
Okay. Is Woody's currently operating under the
Yes.
old license?
Yeah, the way it happens is that when the city, when somebody receives a special assembly occupancy license, it's typically good for 2 years. It depends on how long it takes for the application to be renewed, but they usually date it 2 years after the last one. And then that's sort of, I wouldn't say the renewal is automatic, because you do have to go through the process. You have to do the posting of the permit application. You have to go through the same police review, L&I review, public comment, et cetera, et cetera. All of that takes place. But while that's being renewed, assuming that you had your license, was there, you're allowed to continue operating while that application is
Okay.
being renewed.
May I address this issue, Mr.
Yeah,
Chairman?
yeah, I will. We'll get back to you in just for a moment. But I want to hear, does anything, sir, give us a name on the record again, please?
Yes, Matthew Minsky for
Min-
Woody's Bar.
Will you spell that last name, please?
Yes, Minsky.
Okay.
Which
Matthew
firm are you with?
I'm with Boqueto and Lentz.
Ropel and Linsk?
Boqueto and Lentz.
Oh, Boqueto and Lentz, okay. All right. Sir, anything you want to add regarding this matter of the SOL license?
Yes, I have two parts to an opening, so maybe I'll start with the mootness of it first, and then we can
Okay.
decide that, and then I can move on to the merits. So I just want to echo what Mr. Reuter was saying, that the application here on appeal specifically names a license that expired on August 31st of 2025. So even if the appellant has their way with everything they're looking for, you can't revoke an expired license. It's expired. The bar has already applied for a new licensure. They've done the posting. They've taken the pictures of the posting. To my knowledge, there's been no objections that they've heard as to the new license renewal. And as soon as that new license is issued, which we fully anticipate it will be, we presume the appellant will again appeal again, and we'll be here before this honorable board with our witnesses and with our experts again. And with the limited time that we have, I don't want to strain the resources of the board and continue this to be heard on an expired licensure when there's just going to be another appeal, likely on the same matter again when the new licensure is issued. And just in that regard, I want to add that this is an L&I issuance under a section of Philadelphia Code that is discretionary. L&I has to consider a number of factors. What they do is they go through those factors, and based on their knowledge and their familiarity with that area of the city, they make a judgment call. And that's what they did. And in this case, the appellant wants to replace L&I's judgment call with their own. And this is a license that has been renewed for the last 20 years. Woody's has been in business in this location for over 45 years. Nothing's new here. Woody's has been operating. This is the 13th Street corridor. There are 52 liquor licenses within a block radius. And they submitted several pictures and images showing the so-called noise or nuisance value that Woody's contributes. This is the Super Bowl win celebrations in the street on the dates. This is the Gay Pride Parade. These are St. Patty's Day parades. All of the dates are these events, these city events. They're claiming that my client closes down the streets. The city closes down the streets because it's such a well-trafficked nightlife area That's why the streets are closed down. And from their pictures, we've also pulled pictures from other angles that were omitted that show extreme activity on the other ends of the street as well. So to blame Woody's for this type of activity is selective. And I also have evidence to introduce that it is beyond nuisance in terms of what they're claiming. There's actually personal vendettas and other things involved that don't involve.
Let me
permit.
ask this question. Will the city have any witnesses?
Pardon me, the city doesn't really anticipate the need for us to produce witnesses. Again, if there are questions about the process, about what did the city receive, to confirm whether or not the city received information, we will be prepared to produce a witness. But again, it's the city's position, it's moot, so we weren't intending to
Mr.
present.
Miskey, had you planned to bring witnesses at all?
Yes, we have several witnesses. We have an
Several
expert
meaning how many?
At least 3 witnesses.
Okay, all right. Mr. Mattioni, you wanted to respond to the issue. I'm considering.
The mootness.
Well, yeah, the mootness, yes.
This appeal is not moot. It's a renewal of an existing license. It's the same license. It gets renewed. It's no different than a driver's license. I get a driver's license every 4 years. I have to renew it. If I get a ticket the week before my driver's license gets renewed, I don't show up at the court and say, hey, you can't issue me that citation because I've got a new driver's license. That citation's not moot. It's the same thing here. You've got a license that gets renewed. It's the same exact license number every time it gets renewed. They don't get a new license number. It's the same. It's renewal. It's not issuance of a new license. It's the renewal of the license.
Would it be your contention that if this case were decided in your client's favor, that would then effectively deny the pending application
Correct.
for a renewal?
And it's that's specifically addressed in the ordinance where if you have a denial or revocation of an SAOL, you cannot get a new one renewed for at least 3 more months. That's specifically in the ordinance. In addition to that, yes, we would file another application to appeal it. They won't let us file one because we have a pending appeal. L&I told me, you can't file another appeal. You have one pending. I went down there personally, met with L&I, and they would not let me file an appeal of the pending renewal. They told me that I couldn't do it. I went down there and tried to file another appeal of the pending renewal, and they wouldn't let me do it. Now, on top of that, there's a whole doctrine of cases called capable of repetition yet evading review, and the application of which should allow this appeal to continue. And what that means is you can't play this game of saying, oh, we've got a new license to renew, you've got to go file another appeal. Every time that comes around, you're never going to get to the actual merits of the case. And the Superior Court said, that capable of repetition yet evading review, that's a doctrine that they follow, and that exactly applies here too. So even if theoretically it's moot, it's not moot because we're going to have the same issues over and over and over again. And the court said, they recognize that in Pennsylvania. I mean, it would be repetitious and crazy to continue to do this. We're not moot because the SAOL renewal isn't going to remedy the problem. There's a problem out there. We're entitled under the SAO ordinance to present evidence, including, because they're supposed to look at the concerns of the nearby neighbors. We are the nearby neighbors. We're directly across the street.
Ms. Mattioni, the issue, I don't think there's any argument as to whether you should have a right to voice concerns of the neighbors. The issue is whether this is the forum to do it.
I believe it is because this
Okay.
is where an appeal comes when a license gets
And-
issued by the L&I.
Sure, and also whether or not it's ripe, meaning that the license that's the appeal is before it has an actual violation and or license before it. So we need to decipher that. Now,
Right.
before we proceed today, we're going to take a short executive session because I want to decide on this matter of whether it's moot or not.
Can I
Yes.
just have a couple very brief, in
Yeah,
rebuttal?
response, please. Yeah.
Again, I great respect for Mr. Mattioni, great argument if it weren't for if you had to retake, but it doesn't work here because when you have your driver's license renewed, you don't have to retake the test every time. You don't have to go through all the eye checks and stuff. Maybe at a certain point you do. But the point is that this review, it is not automatic renewal. It isn't like, okay, you pay your fee, you get the license again. That's true of many, many licenses. It's pretty much true of liquor licenses, things like that. That is not true of the SAOL. You have to go through the full review process. If you didn't, then I would agree with him. He'd be right. The other thing is that it is capable of repetition, but doesn't evade review because it is getting reviewed again by the department, and that decision will be subject to an appeal. If it's denied, Woody's almost certainly is going to appeal. If it's approved, almost certainly PMC is going to appeal. So it's not going to evade review. It's just that we would strongly suggest if anybody's going to appeal it the next time, ask for an expedited appeal, had to get it for this board quickly. Now, again, the next license will be good for 2 years, so it won't expire till 27. There'll be a little bit more time, but because there was a delay in reviewing this application. But again, the only issue that is in this case is the license that expired in 2024. The fact that it has the same number if it's renewed doesn't really mean anything. It's completely new review. So no.
My question is, I understand the license renewal process going to the police and the community and all those things, and that what's involved in the appeal that Mr. Mattioni has filed is that this whole process, he's going to now submit information that essentially replicates that process. And my question is whether when that process took place for the present license, were the same procedures and the same people making the same arguments then? Or is it now saying, hey, geez, this has really become a problem and we want to stop it?
Right.
We really didn't participate, or we didn't.
There's not a forum, Mr. Pincus. There's not a forum. When they go to renew their license, they file with LNI. Yes, there's a poster put up, but there's not a hearing. There's not a thing that says, hey, if you have a concern about this license being renewed, go show up and make your concerns known. No, but in the ordinance, it specifically says when they renew, they have to take into account community concerns. Well, the only way to raise community concerns is to ask for a hearing before this board. This board is the board that reviews whether a license should be issued.
Except that we've heard a number of issue locations, nuisance bars and others, and the community activists engaged, go to the police department, they talk to the captain, they call LNI, they call the elected officials, they create a stink regarding a particular application. So there's certainly an opportunity to do that.
Except there's two things. One, specifically, it says if you want to appeal an SAOL, you go to this board. That's specific on the city's website.
Yep.
Two, the ordinance also says community concerns. The best way to raise community concerns is to have a forum where everybody can understand what they are. If you're just filing a letter or a complaint with LNI, it's not the same thing. You don't
You
get to
can create a
express your
forum.
concern.
Any group of citizens can create a forum with this elected official, call a meeting on Monday night, 1,000 people show up.
But the elected official does not have the power to say, don't grant the SAOL. Only
course.
LNI does. And the only way to
Yeah.
raise that is to show
Okay.
up at this forum and take the appeal. And this is the same exact license. It's the same number. There's no new number. They don't see you get a new SAOL. You get the same one renewed. And they admit that it's renewed because they've said so. They refer to it as a renewal as well.
What we're going to do, thank you very much for your arguments, gentlemen. What we have to do this because we have this hard stop. We're going to take an executive session because we want to determine how to proceed with this real serious question of whether it's a moot matter or not. Okay?
Understood.
All right.
Thank you.
We'll do that. We'll be back with.
Chairman Woodson, can I add just one? Okay.
Okay, gentlemen, we're back on the record. Regarding HA 2024-004234, 1300 Walnut Street, PMC Property Group. After reviewing the preliminary arguments regarding the status of these matters and the argument regarding whether it's a moot matter or not, we've determined that we need to issue a decision on that matter and then before anything else proceeds. And so we're calling the vote on 1300 Walnut Street. This is my vote to consider to be a moot matter, and I'll hear from the board members.
I unfortunately agree that the matter should be considered as moot at this time. And you'll have opportunity, obviously, to pursue appeal.
I believe the matter is mute.
Yes, I agree. I agree with my colleagues. I agree that the matter is moot.
Matter is moot.
And on behalf of the board, we're also advising Mr. Mattione, that if you reappeal, if you submit a new appeal application, will be an expedited hearing schedule. We will work with you to get it expedited as quickly as possible.
I do want the record to reflect Ellen and I refuse to accept another appeal of this.
Well, the process, when a decision is made,
No,
if,
no, 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 not of this decision, of the renewed license, the license renewal. I tried to appeal that. They told me I couldn't because we had an appeal pending.
Well, now you don't.
okay, but what I also wanted to say to you is that what we're very sensitive to the issue of the residents, the neighbors, having to deal with whatever problems that they identified for an extended period. We're saying to you, if you submit another appeal, we will hear it on an expedited basis.
Right, and I'm
So-
saying, how am I going to submit an appeal when I went down to the desk at L&I last week and they refused to
Well-
accept an appeal?
Okay,
Because you had something pending at the present time, but now that matter's been decided as moot. So it would be an appeal should the new license be issued. That's what we're suggesting.
yeah, in the
It's an
meantime.
appeal of the new SAOL.
Yeah, and so in the meantime, the residents, if there's issues, whoever they are, should be organizing themselves along with the elected officials and the police department and others to make a case for it being not renewed.
I understand your comments.
Okay, all right, thank you very much, gentlemen, for your participation today.
everyone.
Okay.
Concludes our matter, sir.
Is there anything else?
That's it,
We
sir.
done? Okay, thank you.